Delivery of judgment. Item number 57.
Allowed.
Item 58.
Dismissed.
59.
Allowed.
Obligement.
60.
Allowed.
Yeah, pleasure. So with regard to item number 52, mal.
Yes.
May I pray for after 3 weeks? Mal?
Pardon?
There is no interim order also. Mal, quashing petition.
You want
After 3 weeks.
53?
2.
Yes.
Date, mal, may I?
Just move aside. You take the date from that side.
Mal,
May I please, Your Honor? Your Honor, I beg to mention item number 40 be urgent today.
40.
Yes, Your Honor.
Huh?
Yes, Your Honor. 4 weeks time maybe.
All right.
Date lordship. Obliged lordship.
Right, please, your lordship. First, I beg to mention item 14.
1-4.
1 for minute. Taking 2 weeks time.
2016 matter you want 2 weeks time.
2 weeks time.
Let it be called up, we'll see. We can't just adjourn it just like that.
I have some,
You wait, we'll see what.
I have some personal problem, Millet. I have to leave the court.
No, we are all right. We'll see what is there in the file. Passing the order. It need not be here, but we want to see the file.
I'm
May it please, Your Lordship, I beg to mention item number 42. Kindly adjourn the matter for today.
Item
Number 42.
42.
42.
What is the difficulty? 2015 matter. Huh?
Not sure, Your Lordship.
You're not sure. Who has asked you to mention?
My senior, appearing on behalf of my senior T-Som.
Huh?
Appearing on behalf of my senior T-Som.
You are for the respondent.
Yes, respondent number 2.
What about petitioner? What about appellant? Have you taken his consent?
Your Lordship.
Come back when the matter is called up.
Yes, Your Lordship.
May I please, Your Honor? I beg to mention item number 29. Kindly adjourn for today.
29 case diary not received, madam.
29. CD not received. List again on.
May I please, Your Honor? This is in charge-sheeted case, Your Honor. Under section 4, NDPS commercial content.
TCR. TCR.
Date, Your Honor, date may be fixed here. 25th of August. Obliged, Your Honor. It will maybe take after some time, Lordship. The senior is on the way.
Yeah, please, your Lord. Lordship, second bail application, Lordship, FIR was registered under section 4 of the POCSO Act, Lordship.
Posco and gang rape, my lord.
Petitioner was arrested on 5/12/25, Lordship.
Charge sheet submitted.
Call for the TCR and issue notice.
This year,
Date to month.
sit submitted, right? See, anything is there?
Period 1 and 2, Lordship, already examined, Lordship.
Number is there?
Posco case, my lord, gang rape.
Case on case
TCR.
number 16 of the 26.
Here on.
Obliged.
May I please, your lordship? Dear lordship, may I kindly see the FIR in page number 15, lordship. The main allegation is, lordship, one person, he boarded the train in search of a job. Now, during this transit, this train was moving from Gauhati to Bangalore. During the transit, lordship, he entered into some, after drinking some wine, he entered into some miscreants with the passengers. So he was threatened by the pantry owner. Now, lordship, I am the pantry manager. Now, what has happened when I have come back, lordship, FIR has been registered under 143, and I have been arrested, lordship. Today is 36 days, lordship. CD may be required, lordship. It is from Kahan PS, lordship. Already
CD.
36 days, lordship, I am behind the bar, lordship.
When?
My lord, CD on 5th of August. 5th of August. Can it be on 28 or 29, lordship? 31/7. 31/7. Deeply obliged, lordship.
Yeah, please, your lordship, for 83 application, my lord. Under section 3512, 111 18 and 109, my lord. From Panbajar, my lord. This is on the first week of August, my lord. It's a
Fourth of
Fifth of, fourth.
obliged. me.
May it please your lordship, in this case, I am led by Mr. K. Chaudhary, senior advocate, your lordship. I am praying for some time, your lordship. Password for the time being, your lordship. Very grateful, your lordship.
Please, your lordship. Raised bail application, lordship, and out of same FIR, lordship, another bail petition is fixed tomorrow, lordship. And I'm giving the number, lordship, just right now, low numbers. After some time, I'm going giving the
List along with
giving number, lordship.
number
Just I'm giving lordship.
on tomorrow.
Tomorrow.
May it please, your Lordship. So this is anticipatory bail application, my lord. The petitioners before your Lordship, my lord, they filed a complaint before the Chief Minister's Special Vigilance Cell, my lord, against the DFO and against some of the persons alleging that they were engaged in illegal sand mining. My lord would find that our complaint at page 31, my lord. This was, my lord, filed on force. Lordship has it on page 31.
Who are you? Whistleblower.
Yes, my lord. Now they have filed a case against us. So at 4/6/2026, my lord, we filed this complaint against the DFO and two other persons, my lord, alleging illegal sand mining, etc. An inquiry has been initiated. On 12/6/2026, the petitioners were called to the office of the CM Special Vigilance Cell. Their statements were recorded. Thereafter, officers from the CM Special Vigilance Cell also went to Hailakandi, my lord, to the office of the DFO to conduct the inquiry. Thereafter, the DFO's office files a complaint against us in that your lordship will find at page 20, my lord. Page 20, my lord.
Page 20 is the present FIR.
Present FIR, my lord. These are the petitioners, my lord. Now the range forest officer, he files this complaint on 27/6/2026, saying that we are involved in, that we are the ones who are involved in this illegal sand extraction and transportation syndicate, my lord. Lordship will also come to page 23, my lord. The informant,
This is not registered as yet.
no registered.
Registered.
Registered. My lord. Next, registered as my lord, Hailakandi PS page 17.
10326.
Hailakandi 103, my lord. Offenses under my lord, cheating and criminal breach of trust, my lord, and forest regulation 41 and 42.
They are involved in my lord, illegal organized sand extraction, transportation, my lord. They are
This is
specifically
breach of
named,
trust.
they are specifically named in the FIR. my lord.
Huh?
One breach of trust that may not be, my lord, otherwise only
Cheating.
schedule.
Cheating will come out with the and for actually, my lord, for even if
On the
the
schedule reveal, my lord, how, why those sections are, my lord.
But things should be revealed by the FIR.
direct provision would have been, my lord, under the Mines and Minerals Act, my lord.
Such an omnibus statement, they are involved in illegal sand extraction and transportation. Some incidents should be reported at their forest officers.
Stated about some field inquiry and my lord, local residents were examined. That is the. that
All of this
all
happens,
those
my lord.
things will be.
They should have taken the trouble at least to mention that in the FIR on what date, what sand was extracted from which range. Something should be there. Just an omnibus.
And all of this happens after we complain to the CM Vigilance, my lord.
Or learned counsel for the petitioner. PP, this is an application under. FIR of the present case has been lodged by the Range Forest Officer. Protection Squad Range, Hailakandi. For the OC Hailakandi PS. Alleging that in course of a field inquiry was learned that 8 numbers of persons as named in the FIR are suspected to be involved in organized illegal sand extraction, transportation syndicate operating under Matijuri range. But no, look, came forward, make any statement. The influence of the suspected myth. How many petitioners?
8, lord. Eight.
All have come.
All of them come, my lord.
FIR. Miss Kara, it is submitted by learned counsel for the petitioner that lodged. SP M Special Vigilance Cell. Inquiry against the DFO, Hailakandi Forest, some other persons. Collection of money, royalty, environmental destruction. Copy of which has been annexed to the instant bail application. It further submitted that lodging of the complaint and subsidiary by the CM Special Vigilance Cell that present FIR has lodged as a counter blast to the to harass the petition. perusal of the specific incident and extraction. Right. And petitioners have been named only on some para in the event of their arrest in connection with the aforesaid case. The interim bail of rupees like amount to the satisfaction of the arrest appear before the IO within a period of 10 days from today for the purpose of interrogation.
Deeply obliged, madam.
FIR, your lordship will find page 18. Your lordship, allegation is that lordship police received an information that one vehicle was carrying some suspected Burmese supari, lordship. Accordingly, they tried to apprehend the vehicle and vehicle somehow escaped and lordship here the vehicle came to my godown, lordship. And after coming to in front of my godown, lordship, he handed over the key to my manager. And subsequently, police came and arrested the manager, and now they are lordship asking me to appear before the police, lordship. And because of lordship, they have mentioned my name in last paragraph, lordship. Therefore, I am apprehending that if I go appear before the police, I will be taken into custody, lordship. Admittedly, I am the owner of the godown, and I am having some documents to run that godown, lordship. Page 11, I have annexed. The driver handed over the key to the manager. That is the case. I was not present at the time of incident, lordship. Driver came and he handed over to manager. And thereafter, driver fled away. My manager was arrested. He was forwarded to court. That forwarding report also I have annexed at page 21.
Is registered under what section?
Under section 3183, that treating, and 317, that receiving stolen property loss.
305C.
305C is there.
Is that? Is 305C. So even you have to consult the book.
305C theft, the theft in dwelling house, lordship.
Otherwise, they fail to produce any valid document regarding possession and transportation of those Burmese supari.
I have
And he is the owner of that godown. Where from those Burmese supari seized?
from godown, Burmese supari was not seized. It was seized from the vehicle, which was, lordship, arrived at my godown and handed over the keys to my manager, lordship. And the driver fled away. He is also in similar business. Maybe they know each other, lordship. That I do not know. I will appear before the police, lordship, and cooperate, lordship. Page 11 is the
Counsel
certificate.
for the petition and learned application under. As per the FIR. Of prior information that sought to intercept one vehicle bearing for AS 19 AC 5191 with suspected Burmese Supari on 0507. But the driver managed, the driver attempted to not attempted to, driver sped away towards Hapachara, was chased by the police, and the vehicle was ultimately apprehended, but the driver fled. Before fleeing, the driver handed over the vehicle to the manager of a godown. In front of which truck was parked. Present petitioner is the owner of the said godown. The owner of the godown involved in transportation of suspected, any transportation of Burmese Supari, not present on. There are learned and it's that the facts CD.
Obliged, Lordship.
My pleasure, Your Lordship. Lordship, for another accused, the matter has been fixed tomorrow for CD, my lord. CD has been called for by the coordinate bench. That may be tagged along with that then.
Release the matter along with.
That is BA 195A of 2026, my lord. It will go to sir. Item number. That has been fixed tomorrow, my lord, in this court itself. 195A. But much obliged, my lord.
There's a application of the section 482, Your Lordship, and the FR is on page number 15, my lord. Is the type copy. Under section 316 and 318, my lord. Para 12, Your Lordship. May I read? May I read, Your Lordship?
I think as earlier cases were also
Yes,
there.
yes, Your Lordship. On the same subject matter, there is a title suit pending, Civil Justice Senior Division 2.
No,
where
no,
they are-
before this court also bail application or something was moved, I think.
Not in this case, similar type of cases, but not regarding partnership deed was there, but not
The same subject matter, Lordship, there is a title suit pending in the Civil Justice Senior Division 2, where the ad interim injunction was paid by both the accused person to restrain the complainant, both the complainant, Your Lordship. And the dishonorable court was pleased to issue ad interim injunction, Your Lordship. Kindly, Lordship, come to page number 93, Your Lordship. Next reads. Subject matter is a civil in nature, Your Lordship. They want to put the color of criminal case, Your Lordship.
The case is based on documents only.
Yes, yes. Initially, my lord, in fact, they stated that they had signed the deed without reading its contents, relying on trust and good faith. In fact, they had made signature in the document, but now stated that on good faith.
Counsel for the petition. Application under is alleged that the complainants had been partners of a firm called Eastern Enterprise. Both are petitioners. Parthasarathi Banerjee is the petitioner.
Yes, yes. Both petitioner number 1 and 2 are the only partners.
Present petitioners were inducted as partners subsequently. However, the petitioners who were subsequently inducted had fraudulently removed complainants from the partnership firm. Is it that they had signed a deed partnership on good faith without knowing the contents thereof? It is behalf of the petitioners that matter a civil suit is pending and court by order dated 26/6 IA Civil 2215 of 2026 in FAO number 41 of 26 had granted ad interim injunction in favor of the present petitioners. Call for the CD. The allegations, it is ten days before the IO. Again on.
I may be protected. Interim period is, yes.
Appear before the IO on 10 days.
Deeply obliged.
May I please, your lord? But here, my lord, the FIR is at page 12, my lord. The informant, my lord, is a highly educated girl, my lord. And they, my lord, were in friendship, my lord, from the college days. According to FI, my lord, since 2018, my lord, they are on relationship, my lord. And it was breakup. Then she developed affair with another boy, my lord. That was also breakup. And she tried to resume, my lord, the relationship. The boy refused. Then this FIR has been filed. And case registered, my lord, under section, my lord, 69, 78 2, 351, 1152, 296, my lord. All, my lord, sections are bailable except, my lord, 69. The ingredients of the 69, my lord, is absolutely missing. In exactly similar case, my lord, your lordship has deal with the issue, my lord, and pass. Coordinate bench of this honorable court, my lord, by relying the honorable Supreme Court judgment, my lord. Case 13, my lord. He has completed, my lord, master degree, then the accused number 3 is, my lord, our third boyfriend, my lord. While he refused, my lord, relation, then this FIR has been filed. Getting onward. This case also, my lord, case was registered under same section. There was a promise of marriage. Marriage was not solemnized. Then this FIR was filed.
Is after CD.
Oh, initially there was interim, my lord. Initially there was interim. Then after appraisal of the diary and judgment of the Honorable Supreme Court, my lord, in this issue, my lord, interim bail was made absolute. I'll cooperate with the investigation, my lord.
Learned counsel. The allegation herein is that the government lady was in and the petitioner into physical relationship with her, but subsequently filed him. Call for the CD. To the nature of the allegations. The event of his arrest, the 50,000 appear before the IO within 10 days. Shall not try to contact or in the petitioner or any other witness.
Continue.
Deeply over.
May please. Fire at page number 10, Lordship. This is the typed copy, vernacular copy, page number 14, Lordship. In this case, Lordship, accused number 4 and 6 and some dispute with the informant, Lordship. Accused number 1, 2, 3 and 5, they have went to the place of occurrence, Lordship, for resolve the matter between the dispute accused number 4, 6 and informant, Lordship. They have also implemented in this case, lordship. There is no grievous hurt, lordship. Only some physical assault is there between the parties, lordship. Accused number 4 and 6 and informant, lordship. Accused number 1, 2, 3 and 5 no way connected with this case, lordship. They have just went to the place for resolve the matter, lordship. The neighbors of the
What is your story?
my story is that, lordship, the day of
Otherwise, my lord,
before
finding sufficient incriminating materials, trial court rejected the bail.
Where is that?
Page 17, my lord.
Page
Page
17.
17. Third paragraph. my lord.
Physical assault is there, lordship, but no grievous hurt at this occurrence, lordship, occurred between the accused number.
After seeing CD, trial court has rejected.
Accused number
See the
4 and
CD
6
first.
is there.
Yes, CD.
On 31/7.
Short date.
How short?
Blind field.
Please, your lordship. Lordship, anticipatory bail application, lordship. Here, my lord, the allegation is that, my lord, we have demanded money from the, my lord, the father of the, my lord, informant for deleting, my lord, videos where, my lord, the father of this informant, he has cut down 3 numbers of trees, my lord. Well, what happened, my lord, actually? On, my lord, the lordship will come to, my lord, the annexure 1, my lord. The father of this petition informant, my lord, he has cut down 3 numbers of big trees of the roadside, my lord. Then there was public resentment. My lord, news was published on 6th and 7th of, my lord, July. On 6th, my lord, it was published in the, my lord, the Proceedings newspaper. Then, my lord, on 7th on the Neomia Bata. Simultaneously, my lord, these are also telecast in TV channels also, my lord, regarding this cutting down of 3 numbers of big trees, my lord, of the roadside illegally. And, my lord, in this respect, my lord, this petitioner number 2, my lord, herein, he has also filed an application before the, my lord, this co-district
You
commissioner. my
already
lord,
uploaded
Bihali.
it and then went for the money.
Yes.
After, my lord, publishing the news, my lord, everything, my lord.
Subsequently, on my lord,
Subsequently, my lord,
If you have already uploaded, why should they pay you any money?
my lord, everything after, my lord, after publishing the news, my lord, everywhere, my lord, they have lost, they come up with this method for deleting the news, my lord, we are demanding money, my lord. How can it be, my lord? And we have also made complaint before the forest range officers. The timbers were seized, my lord. And, my lord, to the, my lord, the co-district commissioner also on 7th, my lord. We have made the complaints earlier to them, my lord. And then, my lord, on the 11th, my lord, actually the
this
news
type of incident, my lord, going on in the name of, my lord, running some portal, my lord. They published news. Thereafter, my lord, demanded money for.
after publishing, if we have to demand money, we would have asked for one before the publishing the news, my
Yes,
lord.
in this case,
While
already
here, my lord, they already news were published in the TV channels also, my lord. And there are various news portals. my lord.
Learned in an application under so the complainant had cut down tree standing periodic pattel and permanent, which act was videographed by the petitioners and uploaded Facebook. Thereafter, the accused persons went to the complainant's house and demanded rupees 50,000 for deleting the video from Facebook. Although the complainant offered to pay rupees 10,000, the these persons did not agree and led to giving threats and intimidation. It is submitted by the video was already uploaded by somebody. Or there is an allegation that approached the demanding money for deleting the call for the CD. 10 days before the IO.
19.
This is.
Wait, please, Rosh. My lord, your lordship would be pleased to see the last order, that is on yesterday one order was passed, my lord. What happened in this case, my lord? The FIR your lordship will get at page 11, my lord.
CD received, my lord.
I read, my lord.
For the fake gold.
My lord, my humble submission before your lordship, I am not named in the FIR. So, my lord, some persons were named in the FIR, and out of that named accused also, my lord, after going through the CD, your lordship granted bail. And another co-accused, my lord.
Anything is there against him?
My lord.
Allegations is there, my lord, against.
Same allegation.
Same against him, he is the prime, my lord. He has prepared the fake vote, my lord.
Your
And
lordship
along with
would
the
be
others,
pleased to
my lord,
see
must
page
be-
15, my lord. Page 15, similarly situated person, my lord, he was also not named in the FIR, and he was granted interim bail, my lord. And thereafter, started.
Today there is no question of interim bail because CD is already there.
My lord, my lord. No, my lord, I am not telling that. Interim was granted and it was made absolute by your lordship starting, my lord, after going through the CD. CD is there, my lord.
Against him, the allegation is defined, my lord. Present petitioners
My lord.
are defined.
My lord, I am similarly situated, my lord. I am not named in the FIR. And your lordship would be pleased to see, actually there is a allegation of extortion, no case of extortion. Sitting is there. That's all right, my lord. We will face the trial. If charge sheet is submitted against me, my lord. I am not named in the FIR.
Continue. Arfan and Lokman, my lord, they are involved in the, my lord, such type of offenses, my lord. And from their statement, it reveals that, my lord, and the present petition, Lokman has prepared the
My
fake
lord,
book, my lord.
Earlier one is
Jabbar.
Asgar.
My lord,
Asgar alias Abdul Jabbar.
my lord, he was an interim, and last occasion yesterday, my lord, he was granted.
Because he was cooperating with the
My lord, my lord, my lord.
Is this page 19?
my lord.
Page 19 order it relates to whom?
Page 19 is regarding this named accused bail, my lord. And 15 is regarding.
Same case.
Yes, my lord. Named accused Montu Deepu Gogoi.
But their
granted
involvement
bail.
is role is defined, my lord. Some of them, my lord, got money for transporting the, my lord, accused victims, and that's why their bill was
My lord,
granted.
your lordship, as your lordship already read the FIR, is there any direct allegation against me, my lord? No allegation. That these are the person, my lord, Rahul, Deepu, Zafar, and Gunga. These 40% committed the crime, my lord. Against me, my lord, there is nothing in the FIR.
And I am similarly situated with Abdul Jabbar, my lord. Asghar alias Abdul Jabbar, my lord. Seizure is already made, my lord. Nothing to be seized. That alleged money is received by somebody else, my lord, not by myself. 26 lakhs. That is the allegation.
He has not been recovered.
Not recovered, ma'am.
You are the main accused.
My lord,
You are the main accused. You initiated everything as per the case diary.
my lord, as per case diary, what FIR is the first information, my lord. There is nothing against me. But in the case diary, my lord,
Arfan statement, my lord.
my lord, your lordship would be pleased to see
Please
the
prepare the-
FIR is the beginning, and that person from whom money has been taken, he is not alleged that I have received the money, my lord. And they did not say that I have handed over the gold. After that, my lord, in the inquiry, if something has come, that is another thing, my lord. When
That
the
is the only thing.
my lord, is FIR, my lord, your lordship will consider from the facts and circumstances.
So are you saying that if it is not mentioned in the FIR, but everything is there in the CD,
No,
then
my
we have
lord,
to go by the FIR only?
your lordship will
Then
consider.
why did you call for the CD?
My lord, your lordship would be pleased to consider the circumstances of the case. A person from Maharashtra alleged that 26 lakhs has been taken by so and so person from me. I am not named. Now, my lord, in the case diary, somebody stated against me, but what about informant, my lord? Informant did not say that gold was taken from me and.
Who received the money then?
My lord, money has been received, that has been mentioned in the FIR. Your lordship would be pleased to see the FIR. Who take the money? Rahul from Assam stayed and said that he knew me and needed my help. And thereafter, my lord, 1 kilogram of raw gold. He wanted to sell me the elevated property. The first time I refused and disconnected the call. Approximately 20 days later, the same person called again, repeatedly urging me and starting that he could show me a sample of gold. Getting swayed by his words, I sent my friend Pramod Jadhav to Assam on December 15 to check the sample. Sample was brought to Maharashtra, and upon checking, it appeared that it was the real gold. Believing this, and with the help of some friends, I arranged a total approximately 27 lakhs on December 19. We traveled from Maharashtra and arrived in Assam. There, Rahul, his driver, and a person named Dipu Gogoi took us in a vehicle to his village in Gauhati, where four other person associates were already present. Among them, one person identified himself as Zafar and another as Gunga, mute. There they took 26 lakhs in cash from us and handed over the alleged gold. Where is my name? If they get me something here in the FIR, then it will be
Money
separate.
can be collected by your agent. What is the difficulty there?
Lord, after all, my lord, this gold was handed over, my lord. Money has been received by somebody else.
Don't say
And
gold.
I am similarly situated with,
Don't say gold.
my lord,
Take gold.
so-called gold, my lord. And your lordship also consider the FIR has been filed from a person from Maharashtra. He's also a greedy person. From far away place, Maharashtra, he has come here to gain something.
What is the guilt in that?
My lord. Your lordship will consider.
Buying
my
gold
lord, I
is not an
forward to
offense.
the
It is not
investigation,
drugs.
my lord. If charge sheet is submitted, I will appear before the court, my lord. And Jabbar has been granted bail. Applying the principle of priority, my lord.
This only for Lokman. This
My lord.
this
Only
other
for
fellow
Lokman.
Arfan has been arrested.
Arrested, my lord. He's a brother, my lord.
I am for Lokman, madam.
Lokman.
On the principle of parity, you should also be arrested.
My lord, Arfan
You
is
said
arrested.
principle of parity.
Abdul
I
Jabbar
didn't
is,
say.
my lord, my humble submission. What is in the city, my lord, I do not know. But my humble
know.
submission,
That
my
is why
humble
I'm saying.
submission before your lordship, Abdul Jabbar is not named. And Abdul Jabbar has been granted bail by your lordship after perusal of the city.
He's only the driver. He just arranged for
My lord.
them to that place. Got some money.
City is before your lordship.
That is what I am repeatedly saying.
My lord, my lord. My lord,
Case of what has been
if charge is submitted, my lord,
discovered,
then I will face the trial, my lord.
what has been unearthed and reflected in the CD, we cannot grant you bail. Here, we hard learned counsel for the application under the allegations is that the accused persons is the petitioners purchase gold pursuant to which the government paid rupees 27 lakhs. Some of the, but ultimately the purported gold turned out to be fake upon testing.
My lord, only one thing, Arfan was arrested and he was granted bail, my lord.
There are learned counsel for FIR named accused and money was received by another co-accused as per the FIR. Furthermore, one co-accused of the case, namely Asghar alias Abdul Jabbar, was granted pre-arrest bail, as also some other one accused, Arfan Ali.
Arfan Ali and Deepu Gogoi, my lord.
And
Arfan Ali, Deepu Gogoi,
they were arrested.
they were arrested and released on bail, my lord.
Deepu Gogoi were granted bail. CD reveals that the along with the other accused, Arfan Ali, father of the present petition, incriminating and on the same footing as the other accused granted pre-arrest bail. The pre-arrest bail is
Lord, petition is rejected, my lord.
yes.
Oblige, your lordship.
Right, please, your lordship. Yeah, this is an application seeking anticipatory bail, my lord. My lord, earlier also against the petitioner, my lord, there was a complaint lodged by the co-district commissioner. Accordingly, my lord, the circle officer was directed to conduct an inquiry regarding this microfinance scheme, my lord. And petitioner appeared and petitioner was asked few questions, then he was allowed to go. Then he was he was also told that he should again come. Therefore, my lord, anticipate apprehending arrest, my lord, we filed the earlier AB number 865 of 26, wherein this honorable court was pleased to enlarge the petitioner on pre-arrest bail, my lord. And the PP, Honorable learned PP was directed to obtain instruction whether any police case has been registered. My lord, if your lordship should kindly come to page 18. Please come to para 4, my lord. However, the present petitioner received a notice from the circle officer Polasbari, and in person to the same he already appeared before the officer on 24/4/26, and he was again asked to appear on 2/5. Till that there is no information regarding registration of any affair, but there is an apprehension of filing an affair in that context, and in view of the above, some interim protection may be provided to the petitioner till receipt of the report from the concerned police station. Mr. Goswami, learned APP, submitted in this regard that one report may be called for from the Polasbari police station as to whether any case has been registered against the present petitioner in the said police station or not on the basis of the complaint. However, it is submitted that no interim protection may be provided to the petitioner. Hearing the submission made by the learned counsel for all the parties, the learned additional PP is directed to call for a report from the Polasbari police station as to whether any case has been registered against the petitioner in the state police station or not. And in the meantime, till receipt of such report or till receipt of the case diary, the police of Polasbari, police from Polasbari police station is hereby asked not to take any coercive against the petitioner till receipt.
So what happened in this case ultimately?
Thereafter, my lord, now matter is fixed on 27/7, my lord. I don't think, my lord, they have been able to produce anything on last day.
Today, the present matter is listed for motion. Regarding that case, my lord, right now, after going through that order, my lord, it came.
No, if that matter, it relates to the same incident.
Same incident.
And why have you come again?
Now they have, now the complaint is to the, my lord, the Corporation Department. My lord, I resigned in 2024, my lord.
I would like to point out, your lordship may kindly come to page 18, my lord. Earlier, my lord, page 18, my lord, third paragraph, my lord. At that point of time, my lord, your lordship, third paragraph, third line, my lord. It is submitted by so and so learned senior counsel that the present petitioner was earlier acting as a president of Rani Bhulabagan Samobai Samiti Limited, but on 23/24 he already resigned from the said post. But this is important next, my lord. But one complaint has been filed before the district commissioner Polasbari with the allegation of misappropriation of rupees 5 crores by the Khudro Sansoy Bank, with the allegation that the money were deposited by some members and non-members through the president of the said Rani Bhulagaon Samobai Samiti Limited. So he is the president of that Samobai
He
Samiti.
deposited the money, but the allegation of misappropriation is against this bank. Misappropriated by Khudro Sansoy Bank.
Exactly, my lord.
That is at least what is reflected in the order.
Yes,
We
yes.
do not know.
That is the allegation, Milord. I was shocked, Milord, when my learned friend was trying to attribute it to the petitioner. Now, Milord, our apprehension is there because of page number 12, Milord. So let my learned friend obtain the instruction. I am not on that. Only thing is, Milord, till then, Milord, I should be protected. And please come to page 12. This has prompted me to file this petition, Milord.
My lord, for a moment, supposing that, my lord, that at that point of time, although, my lord, that allegation is, my lord, from that paragraph, my lord, it reflects that, my lord, total misappropriation of rupees 5 crores. Suppose petitioner is not, at that point of time, the complaint is filed before the, my lord, my lord, co-district commissioner on 33/26. And now, my lord, the complaint is filed before, my lord, assistant register of the cooperative societies. So petitioner is, if the petitioner is not in any way involved in that misappropriation, maybe, my lord, at that point of time, regarding if bank is only involved, my lord, then where is the apprehension, my lord? Initially, my lord, he approached before this honorable court that a complaint is filed before the, my lord, co-district commissioner, and now before assistant register of the cooperative societies. Tomorrow again, he approached that one complaint is there before some other authorities, my lord. And in all cases, my lord, whether the petitioner is
If another
entitled to get
complaint is
protection
filed,
or
I
not.
have liberty to come again. There is no legal bar. Milord, now what had happened, some people are, Milord, conspiring. Now they have filed this complaint before the Assistant Register of Cooperative Societies. They may refer it to police, we do not know, Milord. Here there is no mention of money, Milord. Regarding one Ozoy Kasari and 7 others. Actually, Milord, we as a, Milord, agent of that bank, Milord, we used to deposit the money as a cooperative society. And these are all, as we call in Assamese, Milord, Kudra Khansoy, microfinance schemes, Milord. And the allegation, this I do not know where from this 5 crore is there, Milord. But Milord, if such a mismanagement of such magnitude would have been there, it would have been widely reported and all. There is no allegation, no nothing. Milord, my humble submission is let my learned friend obtain the instruction whether our apprehension is correct or not. But that much. If there is a police case, then Milord, Lordship will consider on the next date. And if there is no police case, Lordship will close the matter. Because there is apprehension, that is why, Milord, the law of the land gives me this liberty to approach this honorable court.
Those monies were deposited before the bank through the present petitioner.
And Milord, if your Lordship kindly comes to page 12, the complaint is of 112. I think the same complaint was before the deputy commissioner, co-deputy commissioner. Now before the, Milord, Assistant Register of Cooperative Societies. Because it has got a criminal element, Milord, that's why we are apprehending arrest.
Has approached court in view of it is director stroke auditor of cooperative society an inquiry the basis of a petition submitted by one Ojoy Kosari and 7 others of mismanagement in the functioning of the mini bank by Rani Bholagaon PSS Limited. Okay. Stated that any FIR has been lodged in this regard. had by way of another arrest bail application being 5 of 2026, apprehending arrest in connection with a complaint dated 30/06 lodged before the Co-District Committee, Palasbari District, and anticipation that an FIR may be registered against the petitioner on the basis of complaint. The aforesaid had granted in protection to the by order dated 004. Matter is now fixed on
27/7.
26.
Can we also tag with that?
Or however, in view of the subsequent complaint and communication referred to above, again apprehends arrest on the basis of any FIR that may have been lodged against the petitioner, the subsequent complaint. In that the petitioner had signed from the presidentship of the said committee
On 23/2/24.
to the above. Call for a report from of which station?
Palasbari.
Palasbari Police Station.
Palasbari PSS to whether any FIR has been lodged against the petitioner. Pending receipt of such or PD, the provided that no coercive action shall be taken against the petitioner. Place the matter on 27/7/6 along with AB
865 of 2020. Biplab.
May please, your lordship. Lordship, yeah, I am paying 2 weeks time, my lord. Last order, my lord, the last occasion I was given some, I want to produce some judgment also, my lord. That I have not got, my lord. I am paying 2 weeks time. One judgment I have submitted before, my lord.
This, I think 142. Court's power is there.
My lord said.
The case where you have been convicted and your but appeal has been dismissed.
Now appeal, it was reduced. Sentence
Right.
was reduced.
Sentence was reduced, but some
Partly
convictions still remained.
Some
Then
portion.
revision. Revision also went against you.
No,
Then where are you here?
my lord, we are here, my lord, it was first conviction of 1 year, then it was reduced to in appeal, it was.
So this is the revision.
Revision.
This is a revision, not criminal petition.
My lord, I need to produce some judgment also, my lord. Due to paucity of time, my lord, I could not.
When can you produce the judgment?
My lord, 1 week time, my lord.
1 week. The prayer of learned counsel for the petitioner. Further 1 week's time is granted. Yes, the authorities regarding the power of the High Court. The sentence. Confirmed by the first appellate court. Again on next week.
I'm deeply.
These two matters kindly be taken as two, Your Lordship. I have some personal difficulty.
In item lordship 16, we have not received notice, lordship. 16 we have received notice, we are appearing. 16 we have not received notice yet.
That you are appearing already.
In item 15 we are appearing. So far as 16 is concerned, lordship, notice was issued, but copy has not been provided. On the last occasion, perhaps these two cases were tagged, lordship.
Different cases tagged together.
Parties are the same, lordship.
Parent is also same, Your Lordship. Case is different.
You have to furnish copies anyway.
I'll provide, Your Lordship. Supply.
So, no.
At 15.
Then not possible, lordship. Yes, checking for fixing it at 2. Today is not possible because after I have to go through the other petition, lordship.
Short date may be given, Your Lordship.
Number 15. Learned counsel for present in along with in 16 you write in 16 you entering appearance for respondent number copy of the petition in on
I'm challenging the order dated 16/7/2025 passed by the Learned Principal Just Family Court Borpeta. Lordship, the Learned Court allowed the maintenance to the husband, which is the petitioner in this matter, Lordship, 2.5K, Lordship. in this matter, petitioner denied that marriage, lordship. Have a look, the notary's agreement, lordship, page number 10, lordship. This agreement, lordship, identification of the advocate is not there, lordship, in this matter, lordship. After that, lordship, petitioner denied the marriage, lordship, in his written statement, which is page number 25, lordship. Point number 5, lordship, as mentioned in the case 1/4/2019, has not executed into any marriage agreement with the first party with full-fledged conspiracy. First party has prepared the document fraudulently. Then after, lordship, TW's 1, which is the Afruja, she stated the marriage. Then after, lordship, have a look. Page number 44, witness number 1, which is the father of the respondent number 1. The father is agreed to respondent because of that is the interested witness, lordship, not an independent witness. And then after, Motaleb Ali, the father, have a look the page number 45, point number 5, lordship. At the time of execution of both the above agreement, both the parties along with me, Motaleb Ali and Jahidul were present in this matter. Motaleb Ali has deposed their witness, lordship, which is page number 47, point number 2, lordship. Point number 3. I do not know whether any marriage was solemnized between Afruja Begum and Mahiruddin. I do not know whether both the parties were leading conjugal life at the house of Mahiruddin, lordship. After that, lordship, the final order, lordship, lordship, page number 57, para number 15. The strict proof of marriage in the proceeding under section 125 CRPC is not essential. In this case, lordship, the petitioner totally denied the marriage, lordship, and the notary person, Mr. Padmanil Sharma, has not examined, lordship, and that whether the agreement is genuine or not, that is not examined, lordship. Then just because of the witnesses, interested witnesses, the learned court allow the maintenance 2.5. It's a completely disputed marriage, lordship. Right now the petitioner already married, lordship, another person, lordship, and he has no way connected to any connection in this respondent, lordship. Kindly the set aside the final order, lordship.
Yes.
Lordship, the trial court has, your lordship, has rightly passed the order, your lordship, as per at page 57, your lordship, as strict proceeding under section 125 is not as. If a male, adult male and female reside together, husband and wife, for some time, it is sufficient for the court to grant maintenance to the wife, provided she can prove that she has been neglected by her male partner with whom she lives. Husband, your lordship, she has established her case by with the witnesses, your lordship, the father, your lordship, and CW1, your lordship, who was present at the time of execution of the agreement, your lordship.
Who is CW1?
CW1 is the witness who signed the agreement, your lordship, and in his cross-examination, your lordship, at Page 56 from the judgment, I'm reading, Your Lordship. From bottom three, Your Lordship. However, in his cross-examination, he reveals he puts thumb impression in Exhibit C1, where Exhibit C1 2 is the signature. Both the parties were present at Pathshala Court for execution of their marriage and put their signature in his presence. From the above evidence of the witness, it became clear that the first party and the second party, Mohiruddin, are from the same village and locality. In PW1 and second party executed Exhibit C1, deed of marriage agreement, on so-and-so date at Pathshala Court in presence of C1 and C2, Your Lordship. And Your Lordship, the amount that has been given, 2,500, is very minimal, Your Lordship. And being staying for as husband and wife, Your Lordship, the trial court has rightly passed the order, Your Lordship. And as per that, Lanya Fan has submitted that she has already remarried, Your Lordship. It's a matter of fact, Your Lordship. And as per section 144(3), Your Lordship, the matter is to be placed before the trial court, Your Lordship, if the same is to be considered, Your Lordship. A matter of fact, is a revision petition, Your Lordship. This statement cannot be entertained. Father has also stated that the marriage was solemnized in presence of him, Your Lordship. W1 is the father, Your Lordship, where he has stated the deed of agreement between the parties were executed in my presence, and upon execution of the marriage agreement, they became husband and wife. Mohana amount was fixed at 4 lakh. No amount was paid to the second party. Second party to the by the second party to the first party on that day in my presence, Your Lordship. And till date, Your Lordship, the area amount is 1,22,500, Your Lordship, is not been paid to the respondent, Your Lordship, wife, Your Lordship.
CW1 is a father, Lordship, that is the interested witness, Lordship. And the marriage agreement was not examined, notary is not examined,
It was
Lordship.
duty of the
It's completely
father of,
because-
it was a duty of the husband, Your Lordship, to examine the notary, Your Lordship. Any dispute
Totally,
regarding the
petitioner is denying the marriage, Lordship. Stated that some signature are taken in a blank paper, Lordship.
So how did you prove your marriage? By exhibiting the marriage agreement?
Lordship, it's a completely civil nature, Lordship. This marriage, we are challenging the marriage in a civil court, Lordship.
Not challenging.
The marriage, Lordship, because it's not the marriage totally disputed marriage, Lordship. Because the petitioner is totally denying the marriage in already stated his statement, his deposition, Lordship.
Your Lordship, the marriage has been established, Your Lordship, by CW1 and CW2, Your Lordship.
CW1 is your father.
Yes, Your Lordship. CW2 is a villager, Your Lordship.
Where is the evidence of CW2?
At page 47, Your Lordship.
Forty-seven, point number 3. I do not know whether any marriage was solemnized between Afroja Begum and Mohiruddin. I do not know whether both the parties were leading conjugal life at the house of Mohiruddin.
But in cross-examination, he has stated, Your Lordship. Page at point number 5, Your Lordship. 5, 6, 7.
Not fact that I put my signature.
The evidence, it appears that you went to the notary and it was executed. In cross-examination, your own uncle admits that both of them went and signed.
It statements are there, Lordship.
No, prima facie. 125 proceeding, court has only to be prima facie satisfied that
My
they were
humble,
in a relationship of husband and wife. And since your own uncle has, despite stating in cross chief that he did not know, subsequently admitted that the agreement was executed. Both the parties went there. So your claim that he made me sign some blank papers and later on converted to, the whole story goes.
my humble prayer is this in this matter, Lordship. Kindly matter may be remand back to the learned court, Lordship, and with fresh consideration accordance with law, Lordship, because no
Remand.
things are not examined, Lordship. That's
It is not examined.
Lordship. Another person, Jahidul, that is not examined, Lordship.
Is satisfied with the evidence as a available, then why should he examine any other person? You have filed a civil suit already. Succeed there, then well and good for you. You have already instituted civil suit.
We are prepared, Lordship. Next to be filed, Lordship.
Maybe you can get a stay there. Right now, he has to survive.
Imam may be released here.
Learned counsel for the field. Learned counsel for the application under section NSS. But challenging the final order dated title. And it's only 2,500 rupees.
But his wife, Lordship.
All change.
And maybe, Lordship, because we have no document, the respondent also the remarrying another person, Lordship.
The present respondent wife as first party had reading the principal judge, Family Court Borpeta, under section 125 CRPC, stating therein that para 2, okay, started conjugal life. Para 2. Second party stroke present. Para 4. Was the case of the second part that as is the party children is 54. Line, last word, the first party. There are the learned. Yes, the court. On consideration of the evidence, the finding that minor daughter of the first party present respondent tenants. However, from the evidence, it has been established that the first party stroke present being the wife of the title to maintenance, granted maintenance to her at the rate of rupees 2,500 per month. Para learned counsel submits that denies the marriage the parties, and that from the evidence, it cannot be that from the evidence on record, it clearly transpires that the respondent had failed to establish her marriage with the present petitioner and grant of maintenance. It is the case of the respondent party before the learned trial court that marriage was executed between the parties on 01/04/2019 by way of a marriage agreement which was executed before the public between the parties in the presence of supports of her aforesaid the first party examined herself and deposed the due execution of her marriage. W1, who happened to be the father of the first party, also supported the evidence of respondent wife. Another witness, that is CW, who was the uncle of the present petitioner, had stated in his exam that he did not know about the marriage the parties, but subsequently during cross-examination admitted that S1 stroke W1 exhibit C1 CW1, okay, which was the real certificate was signed by the parties in and he also identified own signature therein, which prima facie points towards the existence of a marriage parties. Era, as rightly held by the learned below in a proceeding under section 125 CRPC. Strict proof of marriage is not required, and the court dealing with the same has to come to a prima facie view regarding the existing marriage between the parties. Having come to such a view, the learned court below awarded the tenants as aforesaid. Having I do not find any infirmity in the beyond order. Therefore, decline to interfere with. However, the petitioner, however, needless to say, the petitioner is at liberty to challenge the marriage, validity of the marriage, the appropriate forum, comma, if so advised. The sense.
Oblige, Your Lordship.
May I pay your indulgence, Lordship? Lordship, one matter. In the same case, 5 cases has been listed before court number 22, and CD has been received, and bail matter has been heard and granted bail. And Lordship, item 25 has been listed before this court, and CD is not there. So it may be item 25. It may be sent to the court number 22, Lordship.
5. Notice Soikya.
Lordship.
This one. Your name is there.
Lordship.
Item 25.
Same day arrest, same PS case.
Submitted by Mr. S. Goswami, that counsel, that 5 other similar matters arising out of the same FIR before court number A, and the CD is available therein. Hence, transmit the record of the sent is to state court. Itself. Itself.
Obliges.
20.
Eighteen. These are the case, my lord. Complaint was filed
Item
under
17
section
of
4,
the respondent count
142 of NI Act, my lord, and the present petitioner was convicted under section 138 NI Act for case 53, my lord. Case 53. considering the nature of the offense and the other offending facts and circumstances, the accused Srimati Pratibha Datta Kalita is convicted of offense under section 138 of Negligent Instrument Act, and she is sentenced to undergo simple imprisonment of 1 year and further to pay compensation of 3 lakhs. Then the appeal was filed, and appeal was just modified. Conviction is upheld, and the modified part you are absolutely at page 60, page 67. Yes. Page 67. 12. I have perused the judgment passed by the learned Chief Judicial Magistrate Gulagat. The evidence on record and documents were properly appreciated by the learned Chief Judicial Magistrate Gulagat while passing judgment. However, while granting compensation to the respondent, the learned Chief Judicial Magistrate Gulagat directed the appellant to pay rupees 3 lakhs instead of rupees 260. Accordingly, I am inclined to modify the amount as a fine of rupees 260 to be paid to the complainant as compensation. That apart, considering the fact that the appellant is a woman, I am inclined to reduce the sentence of imprisonment imposed on her. Accordingly, the appellant is sentenced to undergo simple imprisonment rupees 6 months, imprisonment for 6 months and to pay a compensation of rupees.
Yes, so what happened now?
So double of the amount is the compensation has been given. Now the complaint has been filed that the check has been dishonored, deposited by the respondent, and process was initiated by the respondent, and demand notice, when check was presented before the bank, my lord, that check was dishonored. So, my lord, the complaint under 42 has been filed. And she had issued demand notice. So, my lord, the 138 ABC, clause ABC, the one of the, my lord, the clause is not fulfilled. That is the notice, page 24. Page 20, whether it is a demand notice. That is only my case, my lord. Whether 138B is complied with. That merit, that you have borrowed a sum of rupees so and so, so and so. That too, when my client passed, pressed you for payment of the said amount in several times, you had issued check various numbers so and so, so and so, so and so. Then 3, that when my client presented the said check before the United Bank of India Dergaon branch, in her account, the aforesaid bank so and so refused to pay the check amount and shown the reason in the memo is that is insufficient fund in your account on dated so and so 4/1/2027, and concerned UBI Dergaon branch have intimated my client regarding insufficient funds so and so. Now, this is the matter that by this notice, I advise you to pay the entire amount of rupees so and so, so and so, so and so to my client within 15 days after receipt of this notice, failing which my instruction goes to my client to knock the so and so, so and so, so and so. What is the demand notice? There is no demand. This aspect of the matter, neither the trial court nor the appellate court has considered the matter. Whether there is a demand notice.
So your objection is to the word advice.
Of course, my lord, the language, my lord, the demand. There is no demand. Requesting to pay, advice to pay. Whether advice to pay is a demand. But the clause 38B says that it should be demanded. Money should be demanded. Maybe it's a word, but it's not a demand. So
After that, read the whole sentence.
Yes, madam. Failing whose instruction goes to client to knock the door of the client law under so and so incomplete, inappropriate form of court to cause it. Be it that the case or complaint of law suit is to be proceed against you, will have to pay the entire amount along with interest cost of insurance. The above fashion transmitted for you to my client so and so and so. What is the demand, madam?
Suppose I put a gun to your head and say, I advise you to pay me 50 rupees, whatever. Will you regard it as an advice or as a demand?
It's an advice, my lord. Advice and demand. Advice is a suggestion only.
No. Suppose I put a gun to your head
Of course, that cannot be a
I
demand.
say
man.
I advise you
No, 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 no,
to
no.
pay me 50
No, man.
rupees.
Therefore, that
Otherwise, I will pull the trigger.
by
Will you
putting
treat
gun
it
in
as
my
an
head.
advice or as a demand?
Oh, it should be a demand, man.
No, it is a demand, isn't it?
Yes, yes.
I say I advise you to pay me, otherwise I will shoot
There-
you.
What advice will not come, man? He will say that no, no, you pay me the money, otherwise I'll shoot you.
That is what he said. I will go to the court. You don't
Yes,
pay.
my lord, whether 38B is complied with, my lord, demand.
So tell us how much cost should we impose on you?
Yes, my lord.
How much cost should we impose on you while dismissing this revision?
What this code? This,
Yes, you are wasting the time of the court.
my lord, what is this, my lord? I have a right to file revision petition, my lord.
Yes,
And why I am wasting time, my lord?
you are absolutely frivolous petition.
Well, why shall I revision? I have a right to file a revision petition before this court, whether filing or
Provided you have a case.
and the complaint, whatever he have filed, there is no mention date that when I have received the amount.
Now you are changing your story.
No. Now I am changing, but there is a one of the clause 138 whether it's complied with, my lord. What is complied with, my lord? The payee or the holder in due course of check, as the case may be, makes a demand for payment of the said amount. Whether advise me to pay the amount and demanding to make the amount are equal. Whether the law is complied with.
Yes. That is all.
Moreover, the complaint which he has filed under section 142, there is no mention about date when I have received the amount. Now here the law I have indicated is the law is not complied with. It's a mandatory provision, man. It should be complied with, my lord. The ABC must be complied with.
Now, where is the provision that the date must be mentioned? You said date is not mentioned.
Yes, in the complaint, when I have received.
Where is the complaint?
Complaint, your lordship will find at page 15. And 16 is the relevant part. That at the relevant time of the accused person's son's marriage, the accused person came to the house of the complainant and requested the latter for financial assistance to the tune of rupees 1,30,000 only, in order to mitigate her marriage-related financial problems, and verbally promised to repay the same. Within what time it is to be repaid, that is also not mentioned. Considering the good relationship between the complainant and accused person at the relevant time, the complainant agreed to request the accused person and provided the accused person with financial facilities of rupees 1,30,000 only in good faith, and the complainant had arranged the said amount from her self-help group. That after repeated request by the complainant to the accused person to repay the money borrowed by her, a sum of rupees so and so, the accused person issued check bearing number so and so for rupees so and so only, drawn on State Bank of India, Dergaon branch, in favor of complainant against the debt repayable to the complainant. In this regard, the accused person had executed a hand note regarding her debt towards the complainant, as well as giving the said check to the complainant after putting a signature in the revenue system of the said hand note. There is no date, nothing, and now. Only that she has issued a check. That check has been now dishonored. Now, whether the provision of 138 ABC is to be complied with or not.
Yes. The date is not mentioned.
Only thing is that check has been issued on 16/12/16, on which was presented before the check, which was dishonored. Then certainly the complaint files and complaint lie, my lord. And both the court did not, my lord, consider the aspect of the matter whether exhibit 2 was a notice or demand notice or just advice notice.
Obviously, it was not raised.
But it's a law, my lord. It should be considered, my lord.
Where in your appeal memo is there?
Appeal memo.
The point of law. So why are grounds required to be mentioned in the appeal memo? You do not mention it in the appeal memo. You do not raise it during arguments. Then you say this point was not discussed.
Whether may I not raise this point again this court? That point. This point that the ABC that did not, my lord, look into it, my lord, or that did not go in that aspect of the matter, whether it's advice or demand.
No, whether you may raise it here or not is a different question.
Now I am
You are
raising.
blaming the court that it has not been.
No,
discussed.
that I have said already, my lord. That both the court, that it was not considered. I have said, my lord, this one. Now I am raising, my lord, this point, whether this is a law or what a law, whether demand and advice are same.
Yes.
As per me, my lord, demand and advice is not same. Demand is a claim and advice is a suggestion only. May be accepted, may not be accepted.
Yes.
Actually, the present petitioner has not challenged the hand note and he has not challenged the liabilities. If there is a liabilities, whether he is to pay or not. My submission is that regarding the demand notice, after receipt of demand notice, whether the present petitioner accused send a reply or not. Regarding challenge this demand notice, no reply notice ever served to the present complainant respondent. Yes, it is not a demand notice. I have no liabilities. I have nothing else. No issue any check, no any promissory note ever executed in respect of 1,30,000. But now, my learned has raised this point before the Honorable Court to fill up the lacuna. And there is no option. The petitioner has a legal liabilities. Accordingly, both the court below has granted the relief to the present respondent by convicting him and as well as awarding the compensation. Appellate court also. In appellate court, that point did not raise whether the demand notice is a demand notice or not. May not having that demand word not amounting to he escaped the liabilities. First point is in particular NI case whether he or she has liabilities or not, lawful liabilities. Raise it, yes, I have no liabilities. Then this Honorable Court may be taken into consideration. Mere technicality on the point of word demand, not having in the legal notice, it is not amounting to escape from the liabilities. My respectful submission in paragraph 4 of the legal notice at page 24. And consider, as slowly reading it, may page 24, legal notice dated 9/1/2017, that by this notice I advise you. To whom advise? His client. To pay the entire amount of rupees 1,30,000 to my client within 15 days. Advocate cannot demand. Client can demand. Advocate on behalf of client may use demand. Not him. Advocate may advise. My learned friend has wrongly interpreted the word advice. Within 15 days after receipt, this notice failing which my instruction goes to my client to knock the door of the court of law under NI Act. Very specifically mentioned word NI Act. In the appropriate form or court to cause recovery of aforesaid amount. That means recovery means that means demand. If I am entitled to get certain lawful amount, then I want to recover. The advocate may advise any client. If party himself give this notice, then what demand may use? But here is an advocate sent to the notice to the accused. Let me advise is appropriate. My learned friend has wrongly interpreted to escape his liabilities. So whether law it say, the present petitioner never challenged the demand notice, never sent any reply notice, never challenge the promissory note, never challenge the check, never challenge the signatures. How he can escape? May technically word demand or there is a no subject heading in the notice that he or she cannot escape from the legal liabilities. Therefore, my respect for some before lordship, that the petition filed by the present petitioner has no merit, it is devoid of merit, just to consume the valuable time of the honorable court and just to try to avoid for his legal liabilities, legal lawful liabilities.
Right.
My respect for some petition has no merit, it is devoid of merit, it may be dismissed and appeal the judgment passed by both the court below. This is my submission.
Okay.
All right.
Awesome.
My pleasure also. This is the appeal against acquittal also. The trial court also convicted the accused, that respondent hearing.
PCR received.
Lordship, LC has been received.
You are appearing for,
Respond number 2.
you can fix it for hearing.
Lordship.
You need paper book.
Paperwork, so,
What is the sentence?
this is NI case loss.
Like this. Position is type form. Handwritten.
Lordship is not legible. There are some vernacular also. They're not legible. So if necessary, Lordship, I also can also translate it, or registry may also translate it. Vernacular person is not legible. The copy that they have provided to me, Lordship.
How will you translate?
Yes, Lordship.
Hard learned counsel for the appellant and learned counsel appearing for the respondent number 2 also had learned additional PP. This year has been. Bill is admitted for hearing. Registry is directed to prepare translated and typed copies of the depositions of the witnesses which are in vernacular.
May I pray one thing, Lordship?
Matter for hearing on. Yes.
I am little bit troubled, Lordship, because at the time of filing this appeal, I basically, Lordship, presumed to say appeal against acquittal. So I did not file any Lordship stay petition. Now, Lordship, the question and error, this respondent has deposited 25%, and that was withdrawn by this Lordship complainant. Now the trial court is Lordship insisting to either to give a stay order of this court or Lordship to pay the amount. That is my problem, Lordship.
File.
I can file, now I can file, Lordship. Give one line consideration, then Lordship, it will suffice.
I think one line consideration regarding lordship, not to
File an IA,
ten lordship. So I'll file
what the rules provide.
last. Obliged, lordship.
Obliged. Yeah, because this is my lord regarding my lord Jimma of a vehicle, my lord, of the petitioner, my lord, for a second, my lord, on last year, my lord, 16/7/2025, my vehicle has says, my lord, in connection with my lord excise list. Thereafter, my lord, whenever two times, my lord, I filed my petition before the landed court below lordship. Whenever I file, my lord, the IO submitted a report, my lord, there is a confiscation proceeding is going on. In which, my lord, I was not have any notice in the proceeding. Now, today also may have, my lord, this submitted there is a confiscation proceeding. The my lord, position, my lord. Moreover, my lord, at case number, my lord, 12, I'm still, my lord, paying the monthly installment of the vehicle, lordship, very new vehicle. Case number 20, 12, my lord, kindly see, my lord. Per month, my lord, 30,000 lordship. So, my lord, my interim damage.
It is registered in Arunachal Pradesh lordship. The instruction.
Same, my lord, same submission, my lord, case number 19.
Cases of Arunachal. That against Hemaji lordship. He is
It is a definition, my lord. Regarding, my lord, there are supposed to be serve a notice lordship. I must serve a notice lordship. Whenever I
process is
page number kindly see, my lord, page number 70, my lord, same submission lordship. Whenever I approach the my lord court below, IO says that proceeding is going on, therefore
their reason
they
is
also, my lord, same. I pay for my lord.
We'll do the confiscation.
No, my lord, just my lord, they have said it. This is, my lord, here.
What is the process provided under the Excise Act? Who is to conduct the confiscation proceedings?
Superintendent of excise.
No court involvement is there. The application is to be filed before the court for confiscation.
My knowledge, my lord, there is no, my lord.
Then what record of confiscation proceeding has been called for?
Therefore, my lord, I pay, my lord, I add, my lord, DC district commissioner as well as the my lord superintendent of excise as a party lord. They did not disclose, my lord, anything, my lord.
Superintendent says that the process is under process.
100%, my lord. Same, my lord. Kindly see, my
because
lord,
of
case number 17, lordship.
details of vehicle not received.
More than 1 year, lordship. I am paying, my lord.
The vehicle is registered in Arunachal.
I am paying, my lord, monthly installment. Time custody may be given, lord.
Where is the
Lordship.
order?
Impugn order, my lord, there is a 2 impugn order, my lord, at case number 17. No, my lord, 19, my lord. 2 orders is there, lordship. 19. Case number 20 is the, my lord, 11. The learned APP objected to the Zimma pair it is state as the state has initiated confiscation proceeding. My lord, order dated 12/8/2025, last year. Again, my lord, case number 21, lord. Then I have approached the learned court below, my lord, on 4/11/2025. On the same date or on the same application, my lord, they have stated. Third paragraph, pages the case record. It appears that by order that so and so this court rejected the Zimma petition on the ground that confiscation proceeding has already been initiated by the state in respect of the aforesaid vehicle. 1 year ago, almost. Now, my lord, same instruction.
So if the confiscation proceeding has been initiated, then you only thing you are entitled to is a notice.
Yes, lord, sir. There is, my lord. There is no confiscation proceeding. Just to deprive my lord. Kindly see, my lord, page number 12, my lord. Still, I am paying, my lord, monthly installment per month 30,000.
Don't pay.
From the last year, lord, sir.
Where are you paying?
30,000, my lord.
It is going to be confiscated. What is the point of paying? Don't pay.
Because there is no amount of confiscation. I'm under impression that I will get back the vehicle. Therefore, I'm paying. That's my lord, NI proceeding will initiated against me, my lord. The confiscation proceeding start time may be intake custody may be given, my lord. Only vehicle, this is my livelihood, lordship. The vehicle is. The vehicle is purchased on lordship 21 February 2025. On July, after 4 months, vehicle says lordship. Very new vehicle.
Yes.
Otherwise, I pay for the excise, my lord. Otherwise, my lord, if confiscation process are started, my lord, the courts normally don't entertain, my lord. But in case, my lord, we intend to start the process, but my lord, the authorities at Arunachal are not, my lord, cooperating. My lord. They're not sending me vehicle details, my lord.
Then, my lord, page number 19, my lord, why they have seen.
Yeah, he has the registration certificate. What vehicle is detail is required from authorities now?
Then now everything is online, lordship.
Otherwise, my lord, we can start, my lord. But otherwise, it's under contemplation. My lord. We are starting, my lord, because it's a repeated offender, my lord.
I'm not here for my lord to direction to
My lord,
proceeding.
fix a date on next week, my lord, so I can get an updated status, my lord, from the excise authorities.
Dated what? It is dated 20th of July. What more updated status is required?
Lord.
I'd learned counsel for the petitioner and learned.
That's to harass my lord, this sir.
You're for whom?
For the excise department.
I'm for DC.
Government advocate.
Yes.
Government advocate for respondent number 2.
I'm for
And
one.
learned counsel excise department stroke number 1. Petition has been preferred, challenging section of the prayer of the petitioner for Jima of his vehicle, which was seized in connection with vehicle bearing registration number, paragraph 2. Okay. Connection with Themazi excise case number 372 of 2025. As per instructions received by letter dated 20/07/2026 from the Superintendent of Excise Themazi, addressed to the Additional Senior Government Advocate Assam, the process of confiscation of the vehicle underway. But due to non-receipt of details of the vehicle from the Lower Siang District, Arunachal Pradesh, the matter has not progressed further. Petitioner claims to be the registered owner of the vehicle and had in that capacity submitted the Jima application before the learned magistrate. A copy of the registration certificate has also been annexed to the instant petition. The information is also available online. Therefore, there ought not to be any difficulty on the part of the authority to commence the confiscation proceedings. Para. That the petitioner shall appear before the Superintendent of Excise Dhemaji within a period of
10 days.
10 days from today, along with all documents regarding ownership and registration of the vehicle in question. And thereafter, the Superintendent of Excise Dhemaji shall complete the confiscation proceedings. A period of 1 month.
1 month.
Period of 1 month thereof. Para, needless to say, in the event that it is found in the said proceedings that the vehicle is not liable for confiscation, the same shall be handed over to the petitioner immediately upon completion of the confiscation proceedings. Petition stands disposed of with the aforesaid directions.
For bail hearing, attend hour 21.
Lordship, I am appearing on behalf of Mr. S. Nawaz, the amicus appointed in this case. Lordship, as far as I have checked on the court site, the victim is yet to be examined. As such, at this stage, bail may not be considered. That is.
What is the FIR?
My lord, the petitioner before the, behind the bar, my lord, 254 days, my lord. Also, can you see FIR at page 15, my lord? Incident happened in the year 2022 as per FIR, my lord, and FIR lodged in the year 2025, my lord. After 3 years later, my lord. Page 15, my lord, FIR. Very well.
Also act is involved, Lordship.
Is here.
Lordship.
Charted.
Chartered matter, Lordship.
Just you submitted, my lord.
Call for now the case pending at the stage of evidence, Lordship.
Not examined as yet.
Yes, not yet examined, Lordship. Offense is serious and grave in nature. Without examining the victim.
Also FIR filed, my lord, after 2025, my lord. At least that in the 2022, my lord, the incident happened with the victim, my lord. Now she is 19 years, 5 months, my lord.
Authorization starts in the year 2022.
Because the blackmail continued, she could not file.
Yes, Lordship. The last 3 years, she has been both men.
My lord, he's behind the bar, my lord, 254 days, my lord. Your detention, my lord, he will appear, my lord, he will lordship
Date of
continuously
forwarding
he
is
will
2/11/2025.
contest the case, my lord.
Classified on
He is a local person, my
30/11/2025.
lord. There is no chance of lordship.
If you're tired in 200 days, how will you spend 20 years?
The month of November 2025, my lord, he was arrested.
This is
my
net practice.
State so remains constant.
FIR was lodged soon after the last incident.
Lordship. The incident occurred on
September 25.
yes, Lordship.
FIR was lodged on 6th of October.
6th October.
By her mother, my lord.
Yes, because it was discovered when it was going on.
Why they did not file in
Some
the
people
22,
discovered.
my lord?
Hmm?
Why they
Threatened
did
her.
not file, my lord?
Yes. He has threatened her to kill her.
But
She
this
has
is the statement, my lord.
Hmm.
In
her
every FIR, my lord,
pressure not
every
You have to
disclose
go
the
by the
facts in front
statement
of the
only right
others.
now. If
every
they are
informant, my
tested,
lord, when they file a FIR, my lord, they
go by-
definitely they will prepare a case. my
cannot
lord.
get proof now. We have to go by the statements now.
They had to go under constant mental trauma. Taken twice for
Lordship, any
committing
condition
suicide.
may be imposed, my lord.
Made
He's
by her.
254 days, my lord. Local person, you will appear, my lord. You will contest
No.
the case, my lord.
A totally evil
And
person.
any condition may be imposed, my lord.
He's a married person having 2 children, not committed physical establishment. 16 years old girl under pressure, under mental trauma.
Cases of love relationships resulting in physical relationship, we may take a sympathetic view.
Lordship,
But
as per
this
FIR,
is a
Lordship,
heinous
she
form of
developed,
offense,
Lordship.
blackmailing with
As per
photographs
FIR,
and
my lord,
everything.
this informant
No sympathy can be
Lordship,
there.
developed another girl.
You're the middleman.
Thereafter he
Lordship.
another.
You played a middleman. Heard learned counsel for the petition and learned additional. Also heard learned counsel. And Demicus. And number 2. Application under so and so. The allegations as reflected in the FIR is that the petition acting as a middleman between the victim, who was a minor at the time of initial occurrence, and the former boyfriend of the him had deceptively obtained nude photographs of the thereafter side photographs to blackmail the having sexual intercourse with him on several occasions, which continued up till September 2025, when the matter was discovered. Subsequently, the FIR was lodged soon after. Of the pending for, and the charges have also been framed, and the case is pending for trial. Counsel for the petitioner submits, considering the length of detention of 254
days, my lord.
4 days. Prayer for bail may be considered, particularly considering the fact that the incident relates to the year 2022. A learned additional PP has vehemently objected to the prayer for bail, where the TCR as called for has been received, has been perused. The victim, in her statement before the magistrate, has clearly implicated considering the nature of the offense involving the blackmailing of a minor girl, sexual intercourse, multiple occasions. The prayer for bail is rejected at this stage. Petition stands dismissed.
Please, Lordship.
Your Lordship, kindly fix the matter at 2, Your Lordship. Okay.
Please, Lordship.
For 83 application, Lordship, and this case, Lordship, earlier interim was granted, Lordship, they are in outside, Lordship now. So, and
My lord, here 23, 24, 37, 38, my lord. From the 37, 38, from the same FIR, my lord. 23, 24, 37, 38, my lord. In item 23, 24, there are interim, my lord. And 37 also, my lord, there is interim.
But counsels are not here in all the cases.
No, it's same.
out of same FIR, Lordship.
Same
No,
counsel.
same counsel,
Lordship, I have for
all cases.
Lordship.
So for informant. Even
My Lord, and here this case, Lordship, the item number 23, 24, and 20, 37, Lordship, already in bail, Lordship. 37 is anticipatory bail, Lordship, and 30, Lordship, 23 and 24, they are regular bail, already interim, Lordship, they are in outside. And the
here, Hasina Ahmed, item number 37, my lord, interim was granted on, what the interim is it?
The
Huh?
affidavit.
My lord, here, but her statement is not available in the record, my lord. NCD is up to, my lord, 13.6, my lord. And interim was granted on, my lord, 23.6, no? Is it? Let me-
25/6, 23 and 25.
So get it clarified, we'll take up at 2 all these 4
Fine.
matters. What is where you just Right, we just take all four matters at 12.
Right.
23,
24, 37, 38.
738.
8, my lord. Same FIR, my lord. Same. But her statement is not available in the case record in item 37.
Get to.
Fine.
Four 83 application, Lord. No, behind the bar for 18 days, my lord. FIR is on page 24, Lordship.
It's 9.
Yes, what is the allegation?
But page 9 is the FIR, my lord. Actually, what happened, my lord, in this case, my lord, the petitioner was earlier granted an interim protection from this honorable court in a different case, my lord.
Yes, sir.
So he went there, my lord, to the police station for recording his case in a similar type of allegations, my lord, for recording his statement. Then he was arrested in this case, my lord. Page 9. Page 9 is the FIR, my lord, in the present case.
My lord, here CD not received today, my lord.
Not received.
Not received, my lord.
How many days?
My lord, in this case, my lord, from 3/7, my lord. 18 days, my lord.
Okay, CD not received. List again on give it short date.
So, my lord, short date maybe few because other cases fixed on 4th, my lord. There's a
All right.
Fourth, my lord, fourth, my lord.
oblige your lord.
Yes, my lord. The petitioner is behind the bars since 29 December 2024, my lord. And the FIR is at page number 16, the original FIR, my lord.
Code আছে এটা supply নাই রে।
May I read, my lord?
Page?
Page 16, my lord, original FIR. সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰিউক্ত পদকীয়াজনে যোৱাকালি 27 ডিচেম্বৰ 2024 পুৱা 9 বজাত মোৰ ছোৱালীক মিছ ৰণুমা বেগম বয়স 8 বছৰ নাৰিকলৰ প্ৰলোভন দি ডঙৰপাৰলৈ মাতি নি বলপূৰ্বকভাৱে ছোৱালীজনীৰ পেণ্ট খুলি গুপ্তাংগত পদকীয়াজনে লিংগ হেঁচি দিয়ে। ছোৱালীজনীয়ে ভয়তে ঘৰত কোৱা নাছিলে। আজি 28/12/2024 তাৰিখে ছোৱালীজনী কান্দি থকাত মাকে সোধে, তেতিয়া ছোৱালীজনী সকলো কথা বিৱৰি কয়। This is the facts, my lord.
It is there. Charge sheeted.
My lord, yes, my lord.
Well, yes, trial is going on.
Trial is going on. Out of 10 witnesses, total 6 witnesses has already been examined, my lord. And from the trial proceeding, it appears the matter is under suspicious, my lord. Only on the suspicious ground, the petitioner is behind the bars since December 2024, my lord. Until today, it may be 530, more than 530 days, my lord, behind the bar. And to justify the matter, may kindly be see the page number 2832, the deposition of victim girl, and page number 38 to 39, 38 to 39, the eyewitnesses, my lord. Where is the contradiction found between these vital witnesses, my lord? As per the victim girl, my lord, it stated that the eyewitness has already seen them committing of this offense. But the eyewitnesses denied the same, my lord. He just scolded them to remove the But
From page 30, my lord, vital person of the my lord, examination of PW2 victim girl, 9 years girl, my lord.
yes, my lord. And there is no medical evidence, my lord, as part of medical documents. First, may kindly be see the page number 38, the victim girl's deposition. Sorry, eyewitnesses, my lord. PW5.
W5.
38, my lord, the eyewitnesses of this case. Para number 4, my lord, page 38. Incident occurred in the month of December 2024. On the day of incident, I saw the accused and victim girl sitting nearby the bank of Dong, small river. My house is situated nearby the bank of Dong. As such, if anything happens near the bank of the Dong is visible from my house. After seeing that victim and accused sitting there, I scolded them and asked them to leave the place. I usually scold the children who were found playing near the Dong as there is deep pit near the Dong, which is dangerous. Thereafter, I went to Gauhati for my personal work. After 2 days, I came to know from the nearby people that accused committed sexual intercourse with the victim girl. Per contra, my lord, may kindly be see the victim girl's deposition. Page 28, my lord. May kindly we see the relevant point, my lord, page 30. From para number 3, my lord. On the day of incident, I was in the house of my grandmother and busy in watching mobile. At that time, accused asked me to go with him in the pretext of eating coconut. I denied, but he took me forcefully by gagging my mouth to bank of kernel, where he pulled down my half pant and committed bad act to me, put his penis inside my vagina. At that time, one nearby people witnessed me and the accused. After that, accused was apprehended by that person. I cannot say the name of that nearby person.
No,
but he
164.
resigned-
164 was not recorded.
164, there, my lord.
There.
And also may currently be considered a medical documents, my lord. As part
The
of medical,
informant in his evidence is police did not bring the victim before the judicial magistrate to record her 164 statement.
My lord, I have not checked this, but regarding her statement. But her statement, my lord, what she has stated, it is, my lord, and the medical, my lord, examination report, my lord, opinion. It supported the statement of the girl, my lord, victim girl. My lord, may kindly see the page 42B. Opinion part of the medical, my lord.
it's just opinion, my lord. But what found as per the after examine is nothing, my lord. And already is going to over the trial proceeding, my lord. As out of total 10 witnesses, 6 has already been examined, whereas the 2 vital witness was there. And from the deposition of the witnesses, it is found that it appears that the whole matter is only on the suspicious. And accordingly, my lord, the petitioner is victim of the conspiracy, being a small boy who was just passed out metric bullet. From the
What benefit is to be derived by conspiring against you?
because there is nothing has been proved, my lord. Trial is
My lord, kindly page 42B, my lord. 42B, the opinion. As, my lord, paragraph 22, opinion. On the basis of the physical examination, regular and laboratory investigation done so and so and so, I am of opinion that an attempt of sexual assault has been made with the victim, which is evident from her inflamed vulva.
It is just opinion, my lord. He does not examine still, my lord. Not he,
The
but
trial is almost over. What is the point of?
Yes, my lord.
It will be decided soon anyway.
There's no query of the in this as threatening. As already the investigation part is completed, trial proceeding is almost over, and witnesses has already been examined, my lord.
That is why witnesses have been examined. You have been implicated. Trial is soon going to be over. Why should we risk releasing you now?
As per the evidence, my lord, it is. The medical evidence is not supported as
Only
per
two-
allegation, my lord.
I think only doctor and
As
IO
well
is to
as
be examined.
as well as by the informant, the medical documents also does not support him, my lord.
All right. We'll pass order.
Did you receive money?
মাতি দিব বাকীবিলাক।
My lord, here I have verified, my lord, in item 23 and 37, my lord. She was interim granted on 23/6, my lord.
Items
Item 37, my lord.
37 interim.
Granted on 23/6, my lord. But her statement is not available in the case record, my lord. And CD is up to, my lord, last entry, my lord, 13/6, my lord.
Okay. Then
And my lord, 38, my lord, not interim, no interim was not granted. And 23, 24, they are interim, my lord. The last question.
CD is updated.
Is up to, my lord,
Their statement is there.
13/6, my lord.
Their statement is there.
My lord, their statement, my lord, they are already arrested, my lord.
Regular bail.
Suleiman Ali Borbia, their statement, earlier statements are there, my lord. Before
Then interim means interim bail was given.
Lordship.
bill was granted, my lord. The regular bill, my lord. Their statement is earlier statements are available before the interim. But after the
38 is a regular or a BA?
AB Lordship.
AB, my lord. 37, 38 AB.
My lord, and she was appeared before this IO Lordship, and her statement already been recorded, Lordship. But that CD was here.
What is the case about?
That Lordship, and there was the Marpit Lordship, but the
Informant submitted some
Affidavit, my lord. In the last occasion, on the basis of that, my lord, interim bill was granted, my lord.
all in 30.
Objection. No, no.
Now you are objecting. Before you filed affidavit,
Yes, yes.
saying no objection.
Objection is there, Your
Which case?
Honor.
Item 23.
37, Your Honor.
No, who is 23?
23 is the
In,
Lord.
23. You are appearing for 23 also. Item
Mhm.
23.
All of the
Not yet
cases,
now. All of the cases linked by the same FIR, Your Honor. And
same.
Oh, what we are
affidavit
saying, is that in item 23,
24.
this is an affidavit.
You have filed the affidavit?
You have filed an affidavit. Syed Ali.
Syed Ali, yes.
Syed Ali.
Informant, Your Honor.
Yes, you said that Baharul Islam and Suleiman Ali Bhuya have no involvement in your affidavit.
No, that is your the informant himself before Your Honor. This very affidavit on which in.
So it is a false affidavit. Your signature is not yours.
No, that is a different, sir. Page number 5.
You filed the objection.
Yes.
You have filed
Yes, objection.
Objection is here.
on which date you have filed the objection? Friday.
Last Friday.
Last Friday, and that is 17.
17, yes.
17. File করা হয়ে গেছে?
Oh, fine.
When you file?
17, Your Honor.
I don't think it is here.
But otherwise, Lordship, and I have received the objection, Lordship, filed by this my learned friend, Lordship. But the contents of the FIR and the present affidavit, Lordship, totally different. There is no corroboration.
Now we'll go to that later.
My lord, my lord.
Point is that the
You
informant.
have filed an
never-
FIR, you have filed an affidavit on the basis of which interim protection was granted to you.
Lordship.
He says, what does he say in his objection? That he did not execute this affidavit?
And that will be, Lordship, and otherwise, Lordship, it is a part of record, Lordship, and it is placed before the CGM court, Lordship. And when the accused was arrested, on the same date, Lordship, the informant was appeared before this court of learned court below and submit this.
Where is your
affidavit,
objection?
Lordship.
Give your
I
copy.
do not understand, Lordship, what type of
Yes, sir.
submission is making before this court, Lordship.
এখানে
But otherwise, Lordship,
We are not getting letting go of this matter lightly.
my lord.
yes, Lordship. Affidavit
Page
is on
number 4,
30
my lord.
July, Lordship, that is shown on 30
Paragraph
May.
5, 6, 7.
So you do not deny your signature. You say that it was obtained by practicing fraud.
Oh.
So have you lodged any FIR in respect of this fraudulent activity?
Not yet, no. Because,
So?
Your Honor, the petitioner is illiterate and villagers. Just he has known about this
Yes,
matter.
he is so illiterate that he can file an objection in the High Court, but not an FIR in the police station.
Exact.
He has revealed about these things because he has misled, Your Honor, by this person, that is Ayub Ali, I think. He has also doubt about these things that papers may be
Page number 5, Lordship, of the objection, Lordship, there are 3 numbers of person. And apparently, Lordship, and they have lead this person to shown this affidavit. But why he is not approached the police or something else, Lordship? And bail is granted on 23 June, Lordship, and subsequently after 47 days, shown this affidavit, they have appeared before this court, Lordship. So affidavit shown in the on 30 May. after 48 days. Lordship, and total subsequent lordship and the story lordship it is, and lordship, the instruction lordship, and he is demanding some money. It is a subsequent affair lordship. Otherwise, the informant and the petitioner are same brother lordship, elder and younger brother. He voluntarily appeared before this court below and so affidavit and also appeared before the learned magistrate. But the learned magistrate was rejected the bail petition only on that basis that section is the session driver. That is why lordship this there was rejected. Petitioner number 1 is just 2 months and he got retired from service lordship, and he was this higher secondary teacher lordship. I have annexed the identity card lordship.
Item number 23. Our learned counsel for the Mr. Informant. Filed under so and so been granted interim bail on the basis of an affidavit that have been sworn by Syed Ali Bhuya stroke informant, wherein it is stated that the present petition is not involved in the objection has been filed on behalf of the informant stating that the question of the informant was obtained by practicing fraud. Some impression on the said affidavit obtained by practicing fraud. By one Ayub Ali, son of Bandu Sheikh, by stating that apart from the FIR already lodged, certain papers were required to be signed for submission before the police and the court. Further stated that believing such representation of Ayub Ali to be genuine, the applicant accompanied Ayub Ali to Alingaon, where by taking advantage of the distressed mental condition of the informant, said Ayub Ali obtained the applicant thumb impression on self, including certain blank papers, which the informant, which was not read over to the informant, had not read over. Stated that the said thumb impressions obtained on the papers were misused, preparing, filing the affidavit falsely, that the informant had exonerated the petitioner. Para perusal of the prima facie indicates that the same was sworn before the Republic at Kamrup, at Amingaon, district Kamrup. Upon being identified by Morjina Ahmed, advocate, on the 30th day of May 2026. Is the injury report otherwise?
Injury report, my lord, here, Lordship may kindly. For that, Lordship may kindly peruse the photographs. Photograph. Injury reports are there also. Previous injury. I see that's right.
Is the rule attributed to the petitioner in item 23, is Soleiman Ali?
Lordship, apparently, Lordship, and it was not.
Statements are there, my lord. Some eyewitnesses are also there.
Involving this one?
My lord, involvement is there.
This Soleiman Ali? This one, and this is the eyewitness.
My lord, but my lord, injured victim, my lord, Fazor Ali Khuya and Ohab Ali Khuya, their statements are not available. And from the medical report, he was in ICU also, my lord, one of the medical report.
That is one part,
Fine.
whether any grievous injury is caused, and the other part is who caused it. Because this affidavit says
Minor.
this person did not cause. That is what we want to see.
My lord.
Determine, we have to take a prima facie
My
view
lord.
of his objection also,
My
whether there is some truth to it. And the eyewitnesses have clearly implicated him, then there is some basis for his objection that it was obtained in a shady manner. Why we want to see the involvement, the injured witness in
Admitted to the hospital also, my lord.
Best person to say.
let us then wait for a while before deciding. Let
Their statement,
their
is
statement also come.
essential.
There are statements of this have implicated the petitioner. But the statements of the injured witnesses available in the CD. Of the above, it is considered necessary to peruse the statements of the injured witnesses as well. Beside the instant bail. On.
My lord, 5th of August, my lord. In the meantime, we will return back the case then. My lord.
Updated form containing
Interim is their lordship.
yes, interim is there.
But in
But
manner in which they
item
have
number 37 lordship and is that say be interim is their lordship, that may be continued lordship. 37.
23, 24 also. 24.
Lordship.
24.
37 interim, 38 not interim.
24 also same order. Here you have not filed the objection. An objection has been filed in the connected PA number 1651 of 2026 stating.
Blush lordship.
37. What is there in third?
AB minus, that is 37. Interim was granted on 23/6.
I think this is the lady.
Lady minus, lady.
GP councillor lordship also.
Huh?
Elected GP councillor lordship.
I think method CD the
One witness said about
is what?
involvement, man. All of them assaulted, man. Along with her name also found in the Amalad state.
That their lordship at Eid festival was their lordship, and he along with her husband and two child lordship came to his parent house.
Did you appear and statement is recorded?
Appear, Lordship,
It is
appear.
not here in the case there, my lord.
Huh?
It is not here in the case there.
Yeah, that is why Lordship, that part is not, it is long pending in the High Court. That is why Lordship, our statement is.
Oh,
not-
yes. Yes. I think we can dispose of this lesson, this burden. So, because record his
Yes,
statement that
my
he has
lord,
appeared.
yes, but in this case also he has filed objection. No?
Yeah, yes, file objection.
You file objection in this case also. In all the cases we file.
This connected, actually.
All
what
four
happened-
cases.
What happened, Your Honor, the government himself before you that he says that.
No, we are asking whether in all the four items we have filed objection because our order has to reflect
Yes,
that.
yes, yes.
It is
four-
there.
four items.
তেনেহলে ইনকানেক্টেড বুলি দিব নালাগে চেক ফাইল কৰিছে সেম অবজেকশন then we'll have it with updated
No,
schedule
no, no.
only.
I will.
Is this matter along with number 37 38 matter along with number 2 দিব on 5th of August 37 38 both.
Problem.
Like, Lordship.
Your Lordship. Yes, Lordship, the case diary was called for. The petitioner is on interim bail. And she appeared and recorded her statement. Interim was granted on 22nd of September 2025.
But she has appeared, my lord. She has appeared corporate, my lord.
What is the date of interim order?
22/9/2025. 22nd of September 2020.
That's my lord, updated CD was called for because the statement of the accused is not available, but there is a note of the IO, my lord. She has appeared, she was allowed to go on bail in terms of the High Court order, my lord. Perhaps statement was not taken. Main culprit is the my lord, accused number 5. He is not before us.
Right. 5 1 2 6 7 all 4 has been received and it appears that person confronted by this court the pit appeared before the IO and her statement has been furthermore it accused of the case is the number 5
My lord.
having having regard to the above of interim period 09/25 is hereby made absolute. The same conditions. And allowed accordingly.
Highly obliged.
After that CD was called for, my lord, earlier CD was returned back. CD, after that CD not received, my lord.
May I please, your lordship? The arguing counsel is out of station, so kindly the matter may be listed on 24th of July.
Up to date CD not received, list again on
24th did not come, my lord, from on 30.
Oblige, your lordship.
Yeah, please, madam. My lord, bail application, my lord, FIR is at page 16, my lord. I read, my lord. Due respect, I beg to inform you that yes, enterprise proprietorship of Tafizul Islam Hajarika, he is the petitioner, my lord, had received contracts for 2 schemes under the Public Health Engineering Department of Sagar, the Khelua Water Supply Scheme and the Nopam Barwati Zone 1 scheme. The proprietor Tafizul Islam Hajarika used fake pipes in all these schemes. Furthermore, all the CIPT certificates required for these pipes were completely faked and forged and submitted to the department authority. Public Health Engineering Department, the departmental authorities at that time, so-and-so, currently working as EEN Sonari PHE and so-and-so currently retired, released the bills completely without any investigation. Even after the fake and forged CIPTs were brought to the attention of the department officers, they released the full bills. The collision with the contractor to benefit unfairly. Moreover, above mentioned schemes, fake pump test certificates were provided and pump bills were released without connecting new pumps. On the other hand, according to PHE guidelines, pipes should ideally be 3 feet deep, but in these schemes, pipes were laid down within 3 inches to 8 inches of depth, and in some places left in the ground without being put in. These are the allegations, my lord. But this FIR was lodged on 16/10/2025. Well, the work order was issued, if lordship may come to page 14, on 10/12/2020. These works were completed in, my lord, in the year 2023. And, my lord, with regard to the allegation of fake certificates, my lord, lordship may come to page 23, my lord. Page 23. This is, my lord, email sent by, my lord, CIPT to the, my lord, executive engineer Sibsagar, my lord.
CSPP, what is there?
And, my lord, there is also an inquiry report, my lord.
Low category material, somewhere something, my lord, some as per the statement of witness also there, my lord. But my lord, he after the interim order, he has appeared, his statement recorded. He denied all this, my lord. Earlier it was done, he has denied. Now, my lord, investigation is still going on, my lord. Is there, my lord? Otherwise, he has participated in the and
There is this document
regarding the
saying that
document,
the
those are
pipes are matching with the.
those are, my lord, still investigation going on, my lord. Statement of witness, this is not matching, but proof did not yet come out, my lord.
But there is one, I have annexed the investigating, one inquiry report, my lord, that is at page 26, my lord. Inquiry was conducted jointly by, my lord, accounts officer, assistant executive. These first two are the, my lord, schemes against which the allegations are there.
informant. Allegations are there, the pipe should be dig deep of 3 feet and all this. They are not given 2-3 inches depth. They have fitted those pipe. Some allegations are there.
Inquiry report, my lord, it is stated that my lord, the authorities are not allowed to dig, my lord, beyond that. The inquiry report, my lord, if lordship may case take up my lord page 26, my lord. The first Khelwa PWSS, then my lord, the first one, pipeline depth have been checked at 5 random places, and the depth of the UPVC pipe is found to be about 250 mm to 300 mm. The pipelines are laid over a
300 mm means
millimeter, my lord.
how many feet?
10 mm 3 inch.
Millimeter. My lord. But it says, my lord, the pipelines are laid over a embankment of Water Resource Department, where they have not allowed to excavate more than 300 mm. So
Yeah.
the department has not allowed to excavate.
300 is around 30 centimeter.
And my lord, this work is, my lord, repairing as well as, my lord, installation, both, my lord. So the all pipelines are there, my lord. So these are all repaired, my lord. This is not a new, my lord. My lord, I am cooperating with the investigation. Let the inquiry go on. I do not have anything to say, my lord. It is not that I have done, even the certificates are genuine. The authorities had, my lord, already issued the documents, my lord. And it is up to the department that, my lord, how the work to be executed, my lord. If the authority did not allow to dig the, my lord, earth, my lord, then how the contractor can do this?
So the contractor.
Contractor, my lord. I am a contractor. I've given all the documents and everything what I have, my lord, and the department have all the certificates, my lord. Because these pipes and everything is to be taken from the, my lord. There are, my lord, authorized vendors, my lord. After about 5 years, my lord, FIR was lodged.
Has appeared before. The attention of the court has also been drawn. The annexure. Of the inspection report has been also annexure. What is this page 23 is annexure what?
Part of annexure 3, my lord. Mail dated 3/3/26.
3
Part of annexure 3.
and which contains a letter 2026 by the
Nodal officer.
Nodal officer CIPET Guwahati, executive engineer PHC Sipsagar Division. Wherein it is stated that the documents and CIPET inspection reports submitted in respect of the work order, scheme and contractor have been verified with the records available, and the details contained therein have been found matching, consistent with the available document. Submits that the investigation, the case is in third para having regard to the above. Years built at 20.
Obliged.
Sorry, my lord, CD not yet received. Oh, sorry, my lord, Sasi submitted. Case number 52/26 dated 31/5/26.
Is the offense?
Twenty-two animal segment. 303 and 305.
These are not Sessions tribal cases, you can appear there.
Available also. In them, protection.
Learned counsel for learned additional PP subjects that CS has already been submitted by CS number
52/2026 dated 31/5/26.
submitted by learned counsel for the petition. Two of the above the petitioner. Learned trial court and file appropriate application. Application. Of file on his behalf. So, order provided. Interim protect granted by order dated 06/04/20 in force for a further period of
Obliged. 32, my lord, is an interim, but they are an interim, but CD not received, my lord.
Malad on
From Gwalpara, Lakshipur.
Gwalpara. 5th of August. Malad.
Other date, Lordship, 6 or 7, Lordship.
Okay. 6th.
Published, Lordship.
33 Malad charge sheet submitted.
Lordship, in
It
terms
is-
of the interim order dated 27/5/26, Lordship, I have appeared before the IO, gave my statement, Lordship. My bail may be made absolute. It was a allegation of theft of some rice and some issue. Police has seized 162 bags of rice from me, which was my purchased rice. I am a rice dealer, Lordship.
What do you want to do?
Made absolute, Lordship. I will appear before the trial court on receipt of summons.
Not make absolute without perusing this.
Lordship.
You may
I
approve
have
the
directed
court-
to appear before the trial court, Lordship. With liberty to,
Already-
until then my liberty may be extended, Lordship.
Same order till last one. 14 days.
Yes, number is 30 public 2026, dated 19/6/26.
Obliged.
Thirty-four, Malad, sorry, interim is there, but CD not received.
Receipt list again. And so interim to
5th of August.
Anticipated bail application, Lordship. That's not FIR named person. The allegation against the petitioner is that selling of fake gold.
what is your name?
Sorry,
Korim
Monday.
Malin is FIR named person.
And we come to page 13 of the petition. OAQ statement, Lordship. Indicated that the present petitioner is a main culprit. During investigation, the mobile phone of one of the FIR name accused, that is Mummy Biswas, that has been seized. And after analysis, it is seen that she had a frequent contact with the petitioner who happened to be the mastermind of the case. The date of occurrence also, since morning, she was constant contact with the present petitioner, Lordship.
Petitioner is ready to cooperate with higher Lordship.
Initially, 50,000 has been in the account. Yeah, thereafter, Lordship, 5 lakhs has been given. The house of the FIR name 2 accused persons. All 3 are entangled, Lordship, in commission of the alleged crime.
My name is 2 person arrested, Lordship.
They have already arrested, Lordship.
One is released on bail.
Their statements reveals the fact that the complicity of the present petitioner in the crime. And the investigating officer also seized the mobile phone of the present petitioner. Made a prayer to the authorized person to collect CDR analysis, lordship. Awaited, lordship. That
Investigation will be completed if lawsuit allow the present petitioner to appear before IO lawsuit.
money is yet to be collected, lordship. 5,50,000 has been. Lordship, one golden color half foot shaped metallic piece. One rated 870 grams in one golden color metallic piece. 0.5 kilograms. One Samsung phone has been seized, lordship, from the possession of the other two apparently accused persons. They have clearly stated in their statements that
Has the complainant identified or who has stated he is involved? Who has stated about the involvement of Karim Ali?
the other co-accused, lordship.
What about the complainant?
Then is the party of Haryana lawsuit.
He is also implicated, lordship.
Huh?
Complainant also implicated, lordship.
FIR not mentioned. Complainant.
FIR, he did not give the name.
Name is, lordship.
The
Krishan
statement
Kumar,
of
Krishan
complainant.
Kumar, lordship.
Huh?
Krishan Kumar.
Yes, what does he say?
Yes,
Statement.
coming to that, lordship. Particular, lordship, may I read? নাম ঠিকনা ওপৰত কোৱা মতে সত্য হয়। মই গহপুৰৰ পৰা দুটা মোবাইল নম্বৰৰ পৰা ফোন কৰি মালিকৰ মাকৰ চিৰিয়াছলি অসুখ হৈ আছে আৰু চিকিৎসা কৰাবৰ বাবে বহুত টকাৰ আৱশ্যক আছে। তেওঁৰ লগত কিছুমান সোণ আৰু সোণ বিক্ৰী কৰি মাকক চিকিৎসা কৰাব। সেইমতে তেওঁ কথা মতে যোৱা ইংৰাজী 24 তাৰিখে UPI যোগে 50,000 টকা দিওঁ। আজি ইংৰাজী ইমান তাৰিখে মই মোৰ দুজন বন্ধু সহ তেওঁৰ ঘৰত আহোঁ আৰু পুনৰ নগদ 5 লাখ টকা দিওঁ। তেতিয়া পদকীয়া জনে মোক এটুকুৰা ধাতুৰ টুকুৰা দি সোণৰ বুলি কয় আৰু
Photogia means?
lordship,
Which one? Which Photogia?
his name is not mentioned. I'm coming to this, lordship. পিছত জনে আমাক বেয়া ব্যৱহাৰ কৰি টকাসমূহ লৈ নম্বৰৰ মটৰচাইকেলখন লৈ গুচি যায়। ঘৰখন গহপুৰ থানাৰ এলেকাত ৰূপেশ্বৰ বিশ্বাস আৰু তেওঁৰ পত্নী মমী বিশ্বাস হয়। That was given in the house of Mommy Biswas, Rupeswar Biswas, and this person came to the house of Mommy Biswas and Rupeswar Biswas. That is reflected in their statements, lordship. He is the Podokia means the present petitioner.
Any
May I read
trace of the mobile numbers? by
that
which
is,
he was
lordship,
from?
his phone number has been seized, and accordingly it is sent for CDR analysis. That report is awaited.
Phone maybe sent, but whether the number has been verified.
Lordship, that report is awaited, lordship, as per the CD, lordship. Lordship may go through it also.
Because the first clue, the mobile number from
Yes,
which it was
lordship,
called,
that is what
it belongs to whom?
We need the up-to-date case diary, Lordship. And Mommy Biswas and Rupeshwar Biswas, they have clearly stated, I'm reading their statements, Lordship. Mommy Biswas statement, মই এগৰাকী গৃহিণী হওঁ, মই কৰি মালিক নাম শুনিব পাইছো, কিন্তু মানুহজনক চিনি নাপাইছিলো। আজি ইমান দিন 4-5 দিন আগতে কৰি মালি পুৱা 7-8 মান বজাত আমাৰ ঘৰলৈ আহে। মোৰ স্বামীৰ লগত কি কথা পাতিছে মই শুনা নাই। তাৰ 2 দিনমানৰ পিছত দুজন মুছলমান লোক আমাৰ ঘৰত আহি মোৰ স্বামীৰ লগত কি কথা পাতিছে মই শুনা নাই। অলপ পিছত দুজন হিন্দীত কথা পতা দুজন লোক আহে। লোক দুজন বিহাৰী মানুহ যেন লাগিছিল। আটাইকেইজনে আহি মোৰ স্বামীৰ লগত কি কথা পাতি মই ঘৰুৱা কাম কৰি আছিলো। অলপ পিছত আটাইকেইজন আমাৰ ঘৰৰ পৰা ওলাই যায়। ঘৰত সাৰোতে টোপোলাটো দেখা পাওঁ আৰু দেখি অবাক হওঁ যে সেইটো নকল সোণ আছিল। তাৰপিছত মই ঘৰুৱা কামত ব্যস্ত থকাৰ সময়ত সেই নকল সোণৰ টোপোলাটো কোনে লৈ যায় দেখা নাপালো। পিছত জানিব পাৰো যে মুছলমান লোক দুজনে 5 লাখ টকাত নকল সোণটো টোপোলাটো বিহাৰী লোক দুজনক বিক্ৰী কৰিছে। So, again, the statement of the Rupeshwar Biswas, মই বৰ্তমান মিস্ত্ৰী কাম কৰো। মই কৰিম মালি জানো। মই কৰিমক আগতে প্ৰায় চিনি পাওঁ। আজি 4-5 দিন মানৰ আগত কৰিম লগত দুজন লালুকৰ ফালৰ দুজন কৰিমে দুজন লগত অহা দুজনৰ লগত মোক চিনাকি কৰি দিয়ে। তেতিয়া কৰিম মালিৰ লগত অহা দুজন গামোচাতে কিবা এটা বস্তু বান্ধি আনি দুদিন আমাৰ ঘৰত ৰাখিবলৈ কয়। মই কি বস্তু বুলি গম পাবি বুলি কয়। গামোচা টকা টোপোলাটো দিয়াৰ সময়ত মই ঘৰত নাছিলো। বস্তুটো দিয়াৰ সময়ত ঘৰত মোৰ পত্নী শ্ৰীমতী মমী বিশ্বাস আছিল। পিছত মই ঘৰত আহি টোপোলাটো খুলি চাই দেখো যে গামোচাখনৰ এখন নিচিনা সোণালী ৰঙৰ বস্তু আছে। এইটো কি বস্তু বুলি সোণ যোগে সোধাত নকল সোণ বুলি কয়। ইংৰাজী 24 তাৰিখে পুৱাৰ ভাগত দুজন বিহাৰী মানুহ আৰু কৰিমালি সহ 3জন লোক আহে আৰু লালুকৰ ফালৰ পৰা অহা লোক দুজনে নকল সোণৰ টোপোলাটো পইচা দিয়া বা লোৱা মই দেখা। There's a clear indication of
who
visibility
collect
of the
through Google Pay money? Who received the money advance in Google Pay?
Lordship make tell case diary.
What Google Pay are you saying?
Who received in advance money through Google Pay? Allow me to appear before IO, then everything will be developed.
Kutubuddin Ahmed. Busy. Some friend or relation of yours who received the advance.
My petitioner name is Korimali. My petitioner name is Korimali.
Some other Rohimali is also mentioned now. Last page. I have made several attempts to apprehend co-accused Rohimali. Now, who is this Rohimali? There appears to be only 3 persons.
Yes.
Rohimali and these 2 persons. Rohimali now.
Ali Korimali is the same person. That we don't.
Will need counsel for. Yes, that the type of the mobile numbers involved in the case are yet retained. Here, respect thereof to be obtained. Taken regard adjudication of the petition. Stated CD is sent back submitted in updated regarding along with the requisite information regarding the mobile phones. Where
If possible, Lordship, allow me to appear before I will.
10 August, no?
If possible, Lordship.
that will be same.
This section will be completed.
Can allow you to appear before the IO. That is all right. You can.
I need some protection, Lordship.
By giving you the, without getting the requisite information, we are giving you the benefit of. And there is material against you already.
10, 8. Obliged, right?
This case, my lord, the allegations of theft of a diesel, my lord, and thereby the informant has causes a loss of rupees 9,000 has been alleged against me, my lord. At page 10 is an affair, my lord.
CD was called for. We have not received the case, Your Lordship.
Second time, my lord. My lord, since my lord, the issue involved is regarding a theft of a diesel, my lord, and the loss that is caused to the informant, my lord. The 3 informants come up, my lord. Specific allegations against me was made by informant number 1, my lord, and saying the loss of rupees 9,000, my lord. So may I pray, my lord, if I may protect it, my lord, I'll record my statement, my lord. CD will reveal everything, my lord.
All put together 400 liters of diesel, 2 numbers of jack and 2 sets of wrenches from the said vehicles. Total 5 vehicles. They have allegation of stealing, Lordship.
And my lord, if the allegation has been made, my lord, if lordship sees, my lord, that
CD was called for, Lordship. Give us a shorter, we will.
That's all right. CD not released again on.
not on Friday, my lord, if is a
Kachar is from Kachar, Lordship. It's not possible.
Monday 27, my lord.
7th, Lordship.
27, my lord. Already, my lord, police is after me, my lord. 27, my lord, on Monday, my lord. Already, my lord, twice, my lord, lordship has called for, my lord.
On 3rd, Lordship.
Third.
Third, my lord, I have some difficulty, my lord. Can it be, my lord, prior to that, my lord?
Can be only after that.
Then, my lord, 4th, my lord. Obliged, my lord.
Highly obliged, Lordship.
That's it. Regular bail application behind the bar since 1/6/2026, 51 days, 22. Initially, allegations are of criminal breach of trust and cheating, my lord. Subsequently, sections were added. Also, you will find the FIR at page 17. Read the FIR, my lord.
Yes. Yes, they received, my lord. There are, my lord, similar nature of, my lord, 21 numbers of cases, my lord, pending against the present petitioner. In some cases, my lord, search sheet submitted. What he has done, my lord, he has in fact, my lord, forged the registration certificate of the document. Thereafter, my lord, changed the mobile number attached with that, my lord, registration certificate, and thereafter, my lord, sold the vehicle in, my lord, Manipur, and my lord, and different registration number, that is MN01 CS2545, my lord. Again, my lord, new registration number, chassis number is same of the vehicle he had seen, but till now that vehicle not yet recovered.
My lord, although there are cases, I have also appeared in cases which were seated, my lord. And is there, these are all allegations, is there any, whether IO is able to seize all these false documents? These are absolutely false allegations, my lord. Admittedly, there are cases. Lordship will decide. I have already appeared. There is no conviction till today.
Conviction takes time.
Lordship, admittedly, Lordship will now consider whether his detention in this case is required for smooth investigation. Already 51 days IO.
Detention is required to prevent him from doing further. If
Admittedly, my lord, Lordship will decide.
one. Learned counsel for
Also, I have submitted my medical documents.
an application. So and so. Effect of the case is that the page 20 down below. Aspera. Submits that behind bars for 51 days. Further detention is for the purpose of investigation. Here's from the case diary that the petitioner is a habitual offender. Evidence at least 21 previous cases pending in various police stations. Similar nature of offenses. So according to the IO, in a structured network of organized crime syndicate. Having read to the available in the CD, the prayer for bail stands rejected at this stage.
Obliged.
Made please, your lordship. Here, my lord, one IA has been filed, my lord, for suspension of the sentence, my lord. If your lordship takes up the main case, my lord, criminal appeal number 28, my lord. Lordship, may I kindly have a look at, my lord, page 18, the FIR, my lord. Well, I am seeking for suspension only on two grounds, my lord. In short, I will, my lord. Page 18, my lord. My lord, second paragraph, my lord. Third paragraph, my lord. Accordingly, lordship founded, my lord. Accordingly, I, along with the above police team led by myself, OC so-and-so, staff of so-and-so, my lord, bearing so-and-so, and so-and-so with BSF person proceeded, reached at National Highway 06 and waiting shed. Category under category PS, late ambushed and managed to apprehend one, namely Ali Hussain. Ali Hussain is before a lordship, my lord. So-and-so, my lord. After search, my lordship, kindly note this one word. After search of the apprehended accused person and found 34 numbers of soap cases containing drug substances suspected to be brown sugar, weighing, my lord, 342 grams from his possession, and accordingly seizure was made, my lord. Now your lordship will see the seizure, my lord. 34 numbers of soap cases containing drug substances suspected to be brown sugar, weighing 342 grams. Number two, one white and blue color motorcycle, and third, my lord, one mobile handset number so and so, my lord. Now your lordship will kindly turn to page 20, my lord, the forwarding, my lord. Here also, my lord, the third paragraph, my lord. Accordingly, complainant, along with the above police team led by the complainant and staff of so and so, my lord, bearing number so and so, my lord. Here also, my lord, after search of the apprehended accused person and found 34 numbers of soap cases containing drug substances suspected to be brown sugar, weighing 340 grams from his possession, my lord. And accordingly, seizure was made, my lord. Mixed order. My lord, now, my lord, after, my lord, apprehending this person, my lord, he was produced before the, my lord, the magistrate, my lord. My lord, that orders are in the record, my lord. Here, my lord, below I have given the page number, my lord. Lordship may kindly turn to page, my lord, 9, my lord. Page 9, my lord. Internal page. Order dated 10/1/25. Last one. Lordship for page 9, my lord. Similarly, the prayer to take photographs of the seized items before me is hereby allowed, and the photographs of the seized substances were taken in my presence. I hereby certify that the said photographs are true photographs of the seized substance. Now your lordship will come below, my lord, B, my lord. Thereafter, my lord, from each of the transparent polythene pouches of suspected brown sugar, specimen of small quantity of suspected brown sugar has been drawn from each of the 34 transparent
Of the order dated 10/1/25.
Yes, madam, 10/1/27, madam.
Then of the order internal page.
Internal page, below I have given, my lord, pencil mark.
Below.
Below, my lord.
Yes, below is
10, my lord. Page
10.
10, page
Yes.
10, my lord. B, my lord.
Yes.
Thereafter, from each of the transparent polythene pouches of the suspected brown sugar, specimen of small quantity of the suspected brown sugar has been drawn from each of the 34 transparent polythene pouches of suspected brown sugar and been collected the same together, which weighs 16 grams in total in one transparent polythene pouch, madam. So, my lord, after taking the, my lord, materials from the 34 packets, my lord, they have mixed, my lord. They have mixed, my lord. Thereafter, my lord, 3 samples were, my lord, drawn, my lord. Have been collected the same together, which weigh 16 gram in total in one transparent polythene pouch. Out of the said 16 grams of suspected brown sugar, 3 samples of suspected brown sugar containing 5 grams each have been prepared, and the same is put on 3 different transparent polythene pouches. My lord, if your lordship, my lord, goes to the, my lord, 2020 rules, my lord, for a once, my lord, narcotic drugs and psychotropic substances, my lord, disposal rules 2022. Rule 10, my lord. May I read, my lord? My lord,
Yes, rule.
my lord, rule 10, my lord. My lord, it is under chapter 3, my lord, sampling. Sorry, my lord, rule 10, my lord. Drawing of samples, my lord. One sample in duplicate shall be drawn from each package and container seized. So it should be from each package and container seized. When the package and container seized together are of identical size, weight, bearing identical marking, and the contents of each package give identical results on color test by the drug identification kit, conclusively indicating the package are identical in all respect. The package and containers may carefully be bunched in lots of not more than 10 packages of container from each such lots of package and containers, one sample in duplicate. In the instant case, my lord, when these contraband were seized, my lord, the police investigating agency, my lord, did not test with their identification kit, my lord. So they cannot come to a conclusion that all 34 numbers of boxes are, my lord, of heroin, my lord. So they have mixed up, my lord. So now, my lord, number 3, my lord, 10(3), my lord. In case of drawing sample from a particular lot, it shall be ensured that the respective sample in equal quantity is taken from each package or container of that lot and mixed together to make a composite whole from which the samples are drawn from that lot. So in the instant case, my lord, there was no identification, my lord. The kit which is required by the police authorities, my lord, when the materials were seized, my lord, they should have identified, my lord, with that kit, my lord. In the instant case, they have not done so. And when it was produced before the court, my lord, for sampling, my lord, they have mixed together everything, my lord. And thereafter, these 3 samples were drawn, my lord. The total non-compliance of Rule 10 of these rules, my lord.
Are these procedures mandatory?
Yes, my lord. Well, even I have 34 numbers of box, my lord. In a box, it may contain. But other 33, my lord, there may not be, my lord. So sample ought to have been drawn, my lord, from each of the boxes, my lord. My lord, in this regard, my lord,
Here, what is 34?
34, my lord. Here it says they have done.
No, it has been drawn from each of the 34.
Yes, my lord, that is true, my lord. So lordship will see the last line of paragraph, page 10, my lord. Thereafter, from each of the transparent polythene pouches of suspected brown sugar, specimen of small quantity of suspected brown sugar has been drawn from each of the 34 transparent polythene pouches of the suspected brown sugar. Till here, my lord, it is good, my lord. Next, my lord. and has been collected the same together, my lord, which weigh 16 gram, my lord, in total, in one transparent polythene bag. So after drawing from 34, my lord, they transferred it to one transparent polythene pouch, my lord, that is of 16 grams. But out of these 16 grams of suspected brown sugar, 3 samples of suspected brown sugar containing 5 grams has been prepared, and the same is put in 3 different transparent polythene pouches. FSL. L2 plus FSL.
Yes.
Now, my lord, in this regard, my lord, same issue have been, my lord, decided by our court, my lord. I am relying on order of our court, my lord. So may kindly have a look, my lord. My lord, this Alta Hussain, my lord, from my lord, internal page 6, my lord, from paragraph 22 onwards, my lord. Internal page 6, my lord, paragraph 22. Paragraph 22, my lord. Be that at his may, on perusal of the order dated so and so passed by the learned judicial magistrate first class, my lord, it appears that the seized substance were in fact taken out from the sealed packets before the magistrate, and the ganja from all packets were mixed together on a plain white sheet to form a homogeneous mixture. Thereafter, 3 samples of the said ganja weighing 25 grams each. The same thing that has been done, my lord. Now, paragraph 23, my lord, this rule 3, 2 of the 22 rules, my lord, it has been discussed, my lord. And 24, my lord. Similarly, rule 10.1, which pertains to drawing of samples, provides that 1 sample in duplicate shall be drawn from each package and container seized. However, in the instead case, instead of drawing 1 sample in duplicate from each of the 12 packages seized, in this case, a homogeneous mixture was made, which is contrary to what has been provided in 2022 rules, my lord. Paragraph 30, my lord. The court is of considered opinion that non-following the procedure prescribed by the 2022 rules would amount to violation of the mandatory provision of section 52A itself, And in case of such a violation, the rigors of 37 of the NDPS Act would not apply to such a case, my lord. My lord, in addition to this point, my lord, one more point, my lord, last point, my lord. My lord, section 50 of the, my lord, the NDPS Act, my lord, on a condition under which search of a person shall be conducted. So in the instant case, my lord, he was bodily searched, my lord. He ought to have been searched before a, my lord, magistrate or a gazetted officer, which was not done in the instant case, my lord. And from the seizure, my lord, if my friend record is with him, my lord, from the seizure, my lord, it seems, my lord, 34 numbers of soap cases containing drug substances are suspected with brown sugar have been seized, one motorcycle and one mobile phone, my lord. There is no mention of any, my lord, bag or anything, my lord, there. So therefore, it is a body search, my lord, because the language which they have written, my lord, in page 20 of the appeal, my lord, the forwarding report, my lord, it says, my lord, after search of the apprehended accused person and found 34 numbers of soap cases containing drug substance. After search of the apprehended person. So I was searched bodily, my lord. So if I am searched, my lord, body, my lord, in that case, my lord, it has to be done in front of a gazetted officer or a magistrate, my lord, which was not done in the instant case. Stage, my lord, my sentence may be suspended, my lord. I may be allowed to go on bail.
Lord,
So no recovery is made from the person,
Lord,
but from the bag. Then also section 50 has to be complied with.
Yes, my lord. That's the one.
Having difficulty finding the logic.
Yes. One more, my lord, record. From the record, my lord, I'm taking this record, my lord, for once, my lord. My lord, here, my lord, my submission was, my lord, from each of the 34 boxes, sample ought to be drawn. But one sample, after they were mixed, my lord, 3 samples were drawn. And it is confirmed from there, my lord, the FSL report, my lord. My lord, the parcel consists of one exhibit enclosed in seal envelope. So, my lord, they ought to have drawn sample from each of them, my lord. Because in case of, my lord, if it is a, my lord, cough syrup or say like this, my lord, they can
Seal
do-
things.
my lord. That is a, but here it is a different, my lord, and they have, and the investigating agency, my lord, while arresting me and while seizing this article, they ought to have been ought to have identified with the kit, my lord, because all the police station have been supplied with the kit, my lord, for identification, my lord, drug testing identification kit, my lord, and they have not done so, my lord. So in that case, if it was
When
not
was
done,
that? Earlier it was not there.
not that. No, this is a recent case, my lord, last year,
25
25 case, my lord, that's why I'm submitting. So after this rule came on 2022, my lord, sample ought to have been drawn from each of the packet, my lord. So mixing
The
it,
sample was drawn, but it was all mixed up.
yes, my lord, that is the problem, my lord. That they could not do so, my lord. So that's all.
my lord, regarding the seizure, my lord, yes, it is mentioned that 34 numbers are small swab boxes suspected to be my lord. But it is not specifically mentioned that it is from his pocket, from any bag. But there are my lord, photographs in the record, my lord, to show that there are MR number also there, MR number 025. It is a my lord, gunny bags, which is my lord, tied in the motorcycle, my lord. From the bag, 34 numbers of box, my lord, cannot put in a pocket, my lord. No bags is mentioned, but it is also not mentioned that it is from the my lord, pocket or something. From the motorcycle mentioned, mobile mentioned, my lord, but there are photographs and its MR number is there, my lord. From the photographs. And from the, yes, 34 numbers of, my lord, box. Now sample has been done. Yes, in case of malat any cough syrup and all this, all are sealed. And then malat one sample malat and all this. But now from the each 34 number sample has been drawn. It's not like that the malat that from only 2-3 box sample, all it was taken. But it was mixed up. Malat, that is there.
No, but it will make a difference to commercial quantity also.
Yes, ma'am.
Because if all are mixed and it tastes positive,
My lord.
quantity will matter.
Quantity will matter. Quantity will matter. Malat, otherwise, FSL malat, there is no doubt about it. FSL malat heroin. It is there, malat. Now, if to examine all this, malat, this is a malat recent case only, malat, in December 2025. 25, this conviction has been 10 years conviction, malat. Malat, malat, we have to, malat, if decide this case at this stage, malat, we have to go thoroughly, malat. All these matters, malat. So, malat, only 6-7 months now, malat. Some like, yes, Malat, regarding sample, Malat, I have also, Malat,
We have to decide the IA one way or the other. Cannot say that we'll not decide the IA since this is a recent matter.
but regarding Malat, the seizure, Malat, yes, it is not mentioned from any bag, but it is also not specifically mentioned that it is from his pocket and all this, Malat.
But from the FIR and the forwarding, my lord, they said, my lord, as after search of the apprehended accused. So I was searched.
But it was the bag was Malat tied in the motorcycle, Malat. Its MR number is there, Malat. I have flag mark also, Malat. Malat kindly peruse. And it is from the Malat 34 numbers of box, Malat, cannot be put in a pocket or all this, Malat. And no other bag also seized.
No, I'm not saying that it has recovered, but you have searched my body.
Very, very technical issues, Malat, only.
And DPS, my lord, is a strict act, my lord. So strict. It is a very strict act, my lord. It should be, every rules and procedure has to be followed strictly, my lord.
Some have been helped to be not mandatory.
But
Some of the, even provisions of the act.
yes, that's true, my lord. But so far, rule 10 is concerned, my lord, it is very clear, my lord. It is very clear. He is referring to, my lord, that Supreme Court judgment, paragraph 14, my lord. Says, my lord, it's a stringent punishment. So
These are FSL, everything I have flag mark, Malat, in the.
and this is
Our objection also there, Malat.
Yes, all right, save it.
Thank you very much. I'm obliged, ma'am.
May it please your lordship. Lordship, this has come for orders, my lord. On the earlier instance, on this, which was the second occasion of the date, we had appeared, first and third appearance. Lordship, the TCR, it appears that has already arrived. However, on the last occasion, the service upon respondent number 2 was not completed. So Lordship had directed us to ascertain the proper address and take it. My lord, the only extent that the petitioner has the address, because the FIR was filed by the respondent number 2 in his official capacity of the organization. So we only have this address in the cost title from the FIR. However, we have made endeavors. We have found that, my lord, this organization, All India Services Officers Cooperative Group Housing Society, is a national organization having chapters. So the Gauhati chapter address we have obtained from internet. Lordship will take steps on both these addresses by next week, my lord. Within 2 days, my lord, I'll take it.
Honored counsel for the petitioner submits that fresh steps will be taken on the respondent number 2 within days. Is the matter again after.
Malat, one office notice there, Malat, that 12/6/26, it was returned back, Malat. That is there.
Address he left.
Address, yes, that.
Yes,
So
from
now
new
on both
address.
the addresses we'll take again. Interim as earlier may be continued, my lord. Matter already stayed in another.
Same order passed earlier to continue till the next date of listing. List again on the date.
Deeply obliged, madam.
Please, your lordship. Lordship, IA for bail under special circumstances, lordship. The petitioner, the appellant sustained brain hemorrhage, lordship, while he was in jail, lordship. In this regard, lordship, two up-to-date status reports have come, Lordship. Flagged that.
In the last,
Flag-
Lordship was pleased to call for a report from the Malat.
That is there, Lordship.
It is flag P, Malat.
Flag X is also there. Earlier.
X is earlier.
Earlier.
T.
P is the recent 27, 2026. By the medical and health officer.
Yes.
Malat. Here, Malat convicted under section POCSO, Malat, and 10 years. Regarding his health status, medical was received by Malat. Malat, proper care is going on in the Malat. Care was given to the Malat. Therapy also given to him. And regarding the here POCSO, Malat, informant services. Yes, conviction, Malat. For that purpose also we have to file our objection also.
464 days in custody. Special circumstances we are praying for bail, Lordship. Here is also there, Lordship.
Service is complete, Lordship may fix.
Notice was already issued in the appeal memo.
Final hearing, my lord.
Office note dated. Note dated 2/4/2026.
About respondent number 2.
Notice was issued, Lordship. Office note dated 2/4/2026 in the appeal, criminal appeal, Lordship.
Not returned.
Not returned, Lordship. Lordship may consider, since his condition is very bad, Lordship, he cannot move, Lordship, and requires assistance from others, Lordship. He is not able to go to the bathroom, Lordship. Although physiotherapy is given, Lordship, but Lordship may kindly peruse the earlier report, Lordship. Flag X, Lordship. That is also there. The difference between the time frame is about 4.5 months, Lordship. But his health has not improved, Lordship. Flag X, Lordship. That is 2/3/2026. And subsequent one is 27/2026. In both the reports, it is stated that he requires assistance from others, not able to move properly. His right side has been paralyzed, Lordship. He has suffered intracerebral hemorrhage, Lordship. I have enclosed the document, Lordship. Page 38 of the IA, Lordship. It may consider 464 days. Page 38, Lordship. I've enclosed the report of GMCH, Lordship. City and Geography report, Lordship.
He is not in a position to run away
Yes, Lord. That is well, Lordship.
This is not a normal case of suspension where we consider objection and everything. This is a special circumstance.
Yes, Lordship.
The jail authorities also have very difficulty in keeping a prisoner like this in this. They'll be very happy with if he is allowed to go on bail. But we'll fix it for while granting bail, we'll fix it a date for final hearing also. Not know when that takes place. Condition right now.
Appeal was filed on 29/7/2025.
IA 60 of 20. Council. Having the petitioner. Was convicted.
Section 6 of POCSO Act.
6 of the POCSO Act. By the learned additional has come special. Wow. Undergo RI for 10 years. Pay a fine of rupees 5,000. SI for 4 months. Petitioner was admitted to the jail on 05/2025. Has by now spent how many days?
464 days in custody.
164 of remand period. Is submit in jail. Suffered a brain stroke as a result of which been paralyzed on the right side and cannot move about without the of others. Report was called for from the jail authorities. Accordingly been submitted by A. Ahmed, psychiatrist, legal and health officer, Nagaon. Said report that was sent to Nagaon Nagaon Medical College. Thickness of his upper limb and lower limb within bracket right side, where he was diagnosed as suffering from systemic hypertension and the whole cerebrovascular accident along with intracerebral hemorrhage. So he was referred to ZMCH 26/12/25. wherein he was admitted. Treatment was provided. It is further stated in the same that the not able to walk without help of others. Physiotherapy has been provided from Nagaon Medical College. All required medication provided by the from the jail hospital. Has no doubt been but having the present condition of the petitioner and also the fact that spent days only from jail case, the court is inclined to spend the remainder of his sentence, allow the petitioner to go jail on medical ground. The court has maintained order dated thousand with 20 court to nam to DD. I instance this in appeal, right?
My submission also recorded. Service Mallet and he
Submitted that service on respondent number yet to file its objection to the bill. However, consider in appeal to likable view of disposal of the IA for suspension of the matter for final hearing. 4 episode data DD.
Please, Lord, so I'm appealing for 43, my lord. 42, I think there is another appeal. It's been filed by the informant side, but they are not here, man, for and in 42, my lord. I am for 43, my opinion. Is the conviction under section 417, my lord. But there is another appeal in 42, which have been filed by the informant side, most probably.
There is no one for the appellant.
Yes, my lord. In 42, my lord.
43, you are for the appellant.
I'm for the appellant.
Appellant. What is the case about? Why are they together? Same judgment.
Same judgment. They are filed against for enhancement, my lord. Most probably.
My lord, here, item number 42, my lord, there is a victim, my lord.
Victim.
In this case, my lord, conviction, initially it was FIR on 376, 506, 34 IPC. But conviction was given under section 417.
417.
The promised marriage, my lord. That's why my lord, my lord, victim appeared.
So first we have to decide 43, which is against the sentence.
Against the sentence, my lord.
So
Then it will come, my lord.
if the sentence is set aside, then if that appeal succeeds, then this appeal has no meaning.
Fine. Fine.
So
Yeah, my lord, the old case, my lord, 2013, my lord, occurrence. He was, Joe sentence was given for 3 months, but he had undergone that period, my lord, during the investigation period. Because at that time, the case was registered under section C76, my lord. So at the time, he already 3 months he have undergone, my lord. Period. My lord. Now he is on bail, my lord. That I've seen the record, my lord, in the order. It is, as per order, it is reflected, my lord. He was arrested on 22/4/13. It is a trial court record page 29. And he was released and subsequently on 29/7/13 days, 3 months of 7 days he was in custody. Only that fine remains, definitely.
deposit the fine and we over.
Indian lordship, my only have some. Is that my 470 is also not attractive in this case, my lord. Yes, because the cheating that is, my lord, that is not there since inception. That has to be there, my lordship judgment also there. I have got my disregard, my lord. Cheating must be seen inception, but the accused was having a relationship with the girl for a long time, but then 1025/7 GLT, my lord, one judgment of your lordship is there, my lord, and other judgments also there. Even then, 417 also does not come unless it has to be there since inception or beginning, my lord, regarding that promise to marry, my lord. They also there once he reported, did not report the occurrence also much later, she has after she became pregnant, and that was, I mean, this is why the learned court below, my lord, did not convict the petitioner under C76 under charge that is charge was framed, and instead, 417, my lord. Consensual act was there, both their measure, my lord. Pray, my lord, the sentence may be set aside, my lord, that is. Because
She has initially alleged rape, forcible rape by tying her hands and feet.
yes, initial charge was free, my lord.
That was her evidence. But learned court found that it was
Later on it has come down.
not a case of rape, but promise of marriage.
But 417 is proof, my lord. Here from the witnesses, my lord, it was from the, my lord, beginning, my lord. He has the intention to not marry her, but for the purpose he has used her as a, my lord, sexual purposes, my lord.
Purpose of sitting, my lord, proximity is of time is very important, my lord. That it is a long time, my lord, they have elapsed, my lord. Their relation continued, my lord.
The learned judge, trial court has held that it is found that there is nothing on record to show that at the time of making promise for indulging in sexual intercourse, accused had no intention to marry the victim. What is the meaning of this?
My lord.
No, in the evidence, my lord, the victim, my lord, nothing is there, my lord.
Says there is, that means there is no record to show that accused had no intention of marrying.
My lord.
That means their
The record
intention
is
was
that,
not
that
there.
meaning, that means perhaps.
Then how is the cheating made out? Maybe some grammatical something is
My lord.
there, we don't know. Really what the court tried to say. All right, let's dispose of this. What is the decision you wanted to cite?
Decision of the lord, same,
But
same.
others, my lord, that is, others, my lord, the victim who has filed this appeal, my lord.
Who is representing what to do?
My lord.
Must have lost interest by now. 10 years. Might be happily married now.
Can't keep the case pending for that reason. Since there is an advocate on record.
Lordship, for a moment, my lord, TW5, my lord. Lordship, kindly please TW5, my lord. For a moment, my lord. Paper book is also there, my lord.
That goes contrary to what the victim says.
My lord.
He caught them red-handed.
My lord, got them red-handed, my lord.
Then nothing happened.
Nothing.
He says she did not tell her mother at that time.
My lord. But she said that, my lord, he said that in the next day there is a it was fixed for marriage, my lord. But on the same day he has played away, my lord. On the same day he had played away, my lord. Last part, my lord.
TW5.
TW5, my lord. Second para, my lord. Page 18, my lord.
The subsequent events, my lord. But at the time of the initial, my lord, act, my lord, there was nothing, my lord, getting married. That any promise was made or like, my thing. Thing.
And this is all right. If we are to go by PW5, they were caught in the act. And then he promised to marry.
When it was
From him also, it doesn't come out that he beforehand he had promised to marry and then induced her and all that.
again,
He said they were Bishar was given and it was agreed he will to marry. So it is subsequent event,
subsequent event.
not
When-
before that.
From the cross, my lord, victim, my lord, TW1, my lord. Page 10, my lord. Page 10. It has come out also from the cross of my lord, victim, my lord, TW1, my lord.
Is 10.
Page 10, my lord. 1, 2, 3, 5. Fifth para, my lord. The place, my lord. That's a found, my lord.
W1,
TW1. Where it was so and so, so and so. Last line, my lord. Then accused put so and so, so and so, brought my lord. I struggled so and so, my lord. I got injured on my chest. As accused proposed me to marry. So I did not tell the incident to my mother and the injury which I sustained.
Now, proposed to marry when?
no specific time and day.
On which day it was, but
Whether after the act or before the act, because her act, thing is that it was raped,
my lord,
forcible rape.
my lord.
Where is the question of promise to marry before that?
But in the cross, it was revealed that the accused did not marry me and rather he married the another girl, my lord.
Yes, after the act, he promised to marry, so
Married.
she did not tell her mother. But he did not.
Again, PW3, my lord. Page 14, my lord. PW3, my lord.
Yes.
Accused had love affairs with my said niece for last 3 years. Accused told me that he loved my niece and wanted to marry her.
This is also in his favor. He had the intention to marry her.
But later on, after the incident, he has refused to, my lord, marry.
For whatever reason.
My lord.
That promise is made to another person, even if it is there.
They may have
As per his
fallen out.
submission matter, not to the victim matter.
And the PW1 also in her clause it was disclosed.
To have evidence of PW5, her evidence regarding rape is not credible at all. PW said they found him consensually undressed and believable. Far as even if he promised marriage before that, prosecution is to show that he had no intention from
From the beginning.
beginning. Can be inferred from conduct also, subsequent conduct also. But here there is no specific time stated when he promised to marry her or like that. Before or after. The cases CB. Call or time no was.
Much obliged.
Don't think we'll have time for any other hearing.
Item number 51, Miller. In fact, in that case, we are appearing as legal aid counsel, Miller. Fact is that, Miller, is NDPS case. The revision application is filed against the Miller charge framed by the learned trial judge. But against that issue, Miller, now it is pending since long, Miller. Only the issue, Miller, as to whether the charges framed by the learned trial court, my lord, is valid in the eye of law. Otherwise, my lord, case is going on. Now it is on evidence stage, my lord. Oh, my lord, if it is delayed, my lord, the very purpose of filing the revision petition will be frustrated, my lord.
53.
51, my lord. Krishna Singha, Srimati Krishna Singha. Or she may have it any other day, my lord, but it has to be disposed of, my lord, because if your lordship, my lord,
Next Tuesday.
takes, my lord,
Next Tuesday.
next Tuesday. Yes. my lord.
May I please, Your Lord? Regarding item number 46, my lord, may I pray for a date, my lord?
Yes, he will give you.
Item number 50, can it be next Tuesday? 50.
50.
50. 28. Obliged, madam.
Item 49, my lord. Thursday, my lord.
This Thursday.
Yes, next Thursday, my lord, not this Thursday, my lord. Next week, Thursday. 49. I'm DPW.